Hello my dear students. Now we are going to start our part C. So we have already completed part A and part B. So I hope our 75 marks are in our pocket now, right? So part A 40 marks, part B 35 marks, and now we are going to the part C, which has weightage of over 25 marks. Very important. Why? Because for 25 marks, we only have to learn 3 chapters. Chapter 19, 20 and 21. Okay. Now, among this, if you will ask me, ma'am, which has a high weightage and low weightage, all 3 have equal weightage. Okay. And they ask you question from each of the chapters. So we cannot leave any of the chapters in part C. Very scoring from your exam point of view and very interesting also. In part A, students, what did we learn? We learnt about different forms of organization. We learnt how to incorporate them, right? In part B, we learned the post incorporation formalities, like what are the registrations and licenses required to start a business in particular locality or in the country. Also, we read about various environmental laws, intellectual property rights, okay, which was important for a startup. In part C, we are going to learn about the closure of the entities. So when any of the business house want to close down its entity, what are the different formalities they have to go through? Okay, so in chapter 19, we are going to learn about a dormant company, which is under section 455 of your Companies Act. Under chapter number 20, we are going to learn about striking of the name of company and restoration of the same. In chapter number 21, we are going to learn very interesting thing, corporate insolvency code. Okay, so it's IBC, insolvency and the bankruptcy code. This is the latest code. Okay, so these 3 chapters has a weightage of over 25 marks. Very scoring, very interesting. So without wasting any time, let's begin. So as I told you, we are going to start our first chapter under part C, that is chapter number 19. Before starting this chapter number 19, let us understand about part C. As I told you guys, in part C we have 3 chapters. Okay, how many chapters we have? In part C we have 3 chapters. Chapter number 19, which is your dormant company. Chapter number 19 is a dormant company. Then we have chapter 20. Chapter 20 is about strike off and restoration. Okay, how to strike off the name of the company, how to restore the name of the company. Not only company, but your LLP is also included in this. So striking off and restoration of company and the LLP. After that we have chapter 21. Chapter 21 deals with insolvency and bankruptcy code. Very latest. Insolvency and bankruptcy code 2016. I hope this is very clear. So this part C, the weightage is 25 marks. How much is the weightage? Weightage is 25 marks. So all these 3 chapters we are going to learn in detail. You need to ratify it. Cannot leave anything very important from your exam point of view. Okay, so in order to get 60 plus in SBEC, this part C is going to help you a lot, students. Please remember. Now, let's start with chapter number 19 first. Okay, so your chapter number 19 talks about what is a dormant company. Now, dormant means what? What is a dormant? The dormant company means any of the organization which is not active, okay, is called as a dormant. So any of the promoters of the company who wants to incorporate company now, okay, purchase a property because they are getting at very low prices, but they are not going to start work on that project immediately, but they are going to start project in future. Okay, so when they are going to start their business in future, they are merely holding property by incorporating company. They have an option of a dormant company. So when any company is not doing business, but yes, it is going to do future business, it can apply to the ROC to convert the status of company from active to the dormant company. I gave you one of the reason why any of the promoter will convert into a dormant company. What reason did we discuss? Because it wants to buy property right now because it is getting at discounted price, but the work will be started little later. Okay. The second reason may be due to breakdown of economy, due to breakdown of machinery, due to this COVID, natural calamities, your business has been stopped, disrupted. It can be any reason, but you don't want to dissolve your company. So when you want to continue with the company, but business has been disrupted temporarily, you have option to convert your company into a dormant company. This will save your company from getting dissolved. Also, within few years you can start your business. So these are the various provisions. Okay. So why we have a dormant company? I gave you first reason for holding property. Okay, promoters use this dormant company for holding the property and starting business little later. Okay, business is temporarily disrupted. What has happened to the business? Business has temporarily disrupted. And any other reason, your business has been disrupted only temporarily, but in future you're going to do business. Okay, and in this case promoter don't want to dissolve the company. What they can do, they have to apply to the ROC for conversion of status. Okay, apply to the ROC for conversion of the status. Whenever any company is incorporated, guys, remember it is always incorporated as an active company. Can we incorporate any company as a dormant company? The answer is no, because ROC will tell you, you know that your company is going to be dormant. Why are you incorporating it? Don't incorporate it right now. Do it later on. When your plan is ready, business is ready. So any company, when it is incorporated, it is always active. Point to be written and noted. Very important point. Okay, let's write. When a company is incorporated, it is always active company. Which company it is? It is always active company. So we cannot incorporate a dormant company. Okay. Later, active company can be converted. Active company can be converted into a dormant company. Active company can be converted into a dormant company. Is it clear? Understood? So can any company be incorporated as dormant company? The answer is no, we cannot incorporate as a dormant company. So I hope you have understood what is your part C and what is a dormant company. So now let's begin with our chapter number 19 and let us understand what is dormant company, what is an active and an SAT, that is significant accounting transaction. So I've explained you in the introductory video that what we are going to learn in chapter 19, why we have a dormant company. Can any company be incorporated as a dormant company? The answer is no. But due to some reasons, promoter want to continue with the company, they don't want to dissolve, but temporarily their business is disrupted. So because of that, when there is no business, we have to convert that company into a dormant company. Okay, so our MCA has given a notification on 2013, thereby making provision of section 455, which is your dormant company. So dormant company is defined under section 455 of Companies Act 2013. In that, there is a provision of a dormant company. Also, it has made various rules how to follow the rules, regulations of dormant company, and when to convert your dormant into an active company. So all these rules and what are the rules and regulations of the dormant company, and when can your dormant company be converted into an active company? So this is what we are going to learn. So what is a dormant company? Dormant company is an active company. We will understand what is an active company. But dormant company is an inactive company. So inactive company means it is not doing any business. So it is inactive in records of your ROC. Okay. See students, whenever ROC incorporates a company, it has a register of ROC. In that register, whenever any company is incorporated, the name of that company is inserted. So the name can be there on the register till the time company is active. The moment it becomes inactive, ROC will not keep the name of that company in that register. Understood? So in order to keep that company active, we have to do business, but our business is temporarily stopped. But we are going to do business in future. In that case, we have to tell ROC that please convert our active company into a dormant company for some time. Later on, we are again going to do a business. So, it is an inactive company in records of ROC which is not carrying on any business activity. And also it has applied it to the ROC to change the status in register of companies, as I told you, maintained by ROC from active company to the dormant company. Okay, this is a definition of a dormant company. So when can you apply for the dormant company? Any point of time, immediately after incorporation also you can go for application, or after few years also you can go. So there is no time limit as of applying for the dormant company. Okay. Now I gave you various reasons why anybody wants to convert their status. Okay, this may be asked in your exam, so please mark it. The major reason is when company has to started business after few years. Okay, in that case it may apply to the ROC to change the status into a dormant company. Dormant company are also called as inactive company. Please remember this. One of the advantage of dormant company is it also helps the promoter of company to hold the asset or any of the intellectual property under a corporate shield, because this intellectual property or the asset, we are not going to use it right now, but we are going to use it at a later stage. So when any property you get it at very discounted price, immediately you can incorporate a company and purchase the property in the company's name. Understood? Okay. So if promoter wants to buy land now for its future projects at a lesser price, he may do so through a dormant company so that he can use the land for its future process. I hope this is clear. Now dormant company can be which type of company? Is it compulsory it should be a public company or private company? No. It can be public also, it can be private also, it can be OPC also. Okay, so dormant company can be public, private or a OPC. Please remember this. Okay. So now we are going to learn some definitions about the dormant, inactive and a SAT, that is significant accounting transaction. So what we have learned till now? We have learned that a dormant company, okay, a dormant company, it can be either a private limited or a public limited or OPC. Okay. Okay. So dormant company can be private, public or OPC. When can we apply for a dormant company? When can company apply for dormant company? This we have learned that it can apply any point of time. Okay, so once company is incorporated, after incorporation, it can apply immediately, okay, or after few years. So there is no deadline as of application for the dormant company. These 2 points are very clear. Very good. Now we are going to the next point. What is an inactive company? We have understood that dormant company is an inactive company. So it becomes very essential for us to understand what is an inactive company. What is an inactive company? Okay. So for making application for dormant company, our company has to be inactive. So what is the definition of inactive? Inactive means any company which is not doing any business activity. Okay. So what is inactive? Any company is not carrying on any business activity. Please remember this. It is not carrying on any business activity, or it is not doing any significant accounting transaction. So significant accounting transaction we will write SAT, SAT. But don't get confused, it is not your securities appellate tribunal, but it is significant accounting transaction. The second point is company is not carrying on any significant accounting transaction. Please write full forms if you don't remember. Okay, company is not carrying on any significant accounting transaction, or company has not filed its financial statements and annual return. We know that as per Companies Act, it is compulsory to file financial statements and annual return of the company annually to the ROC. So if any company does not file them, even they will be called as an inactive company. So any company who has not filed financial statements and annual return. So not file financial statements and annual return for 2 years. Please remember, for immediately last 2 preceding years. Okay. So let's again revise the definition of an active company. What is an active company? Any company which is not carrying on any business activity for past 2 years. any company which is not carrying on any significant accounting transaction past 2 years, or any company which has not filed its financial statements on annual return in past two immediately preceding financial year, such company shall be called as a inactive company. So such company can apply to the ROC for converting itself from active to the dormant company. Now the conjunction used between is or. So it's not required that all three condition has to be fulfilled. Any one is fulfilled, you can be a dormant company. So I hope you understood what is an inactive company. Okay. Now to learn this in detail, now remember this very carefully. To learn this in detail, it's important to learn what is a significant accounting transaction. In definition of inactive company, we saw when company is not carrying on any of the significant accounting transaction, it becomes a inactive company. So we have to understand the definition of the significant accounting transaction also. So what is significant accounting transaction? SAT. Okay. What is SAT? Now this definition they have given you little reverse one. Okay. So they have said that whatever points are given here, apart from that, all others are significant accounting transaction. So when company is carrying on this 1, 2, 3, 4, it is not significant accounting transaction. So they have given the opposite one. You will understand. So let's understand what is a SAT. The first point, any company which is making payment of ROC fees. Any company who is making payment of ROC fees, this is not a significant accounting transaction. So making ROC fees is not a significant accounting transaction. Then payment of other compliances. So company is paying for any other compliances. So it is a company, so it has to file various forms, do various compliances. Just because it is doing compliance, it does not mean it is doing a significant accounting transaction. Okay. Third one, it is doing allotment of shares. Why it is doing allotment of share? Because they are bound to do it. If they don't do it, then they will be penalized for that. So allotting the share also does not mean they are doing significant accounting transaction. And the last one, they are spending money for maintenance of registers and records. So for maintenance of registers and records, they are paying fees. So if they are spending for maintaining the register and record, even it does not amount to significant accounting transaction. So in short, all these four does not amount to significant accounting transaction. So when company is carrying on this four, it is not doing any significant accounting transaction. If company is doing anything else apart from this, it is a SAT. And when they are doing SAT, can they be a dormant company? The answer is no, because any company doing SAT is an active company. Is it clear? Sure, everybody understood. Great. Now one more thing, last part in this video. When any company is an inactive company, when any company is an inactive company, so this company has two options. So this company has stopped doing business. So this company has two options. First option is shut down your company. Okay, wind up. Because as of you're not doing business and in future also you're not going to do business, wind up. Other option you have is convert into a dormant status. Okay, these two options we have. If company does not do any of this, so what company is doing? It is not doing business. Still it is not converting itself into an active company. So when a company does default, okay, then ROC have to take the steps. So ROC using his power, it starts the strike off. Okay, what ROC does? Striking off name of the company from register of companies. So when this strike off happens, okay, then ROC cannot revive that company. The bank account will get freezed. Now the company has to go to NCLT because only NCLT has power to revive the company. I hope you have understood. So it's so important if you want your company to convert into a dormant status when you are inactive. If you fail to do so, what will ROC do? Strike off your name. Is it clear, guys? Understood? Now we are going to learn what is a procedure to obtain the status of a dormant company. Now we have two options, okay, for obtaining the dormant status. There are two ways. First, it's a suo motu application by the company. So company knows that it is not active, but it wants to maintain your company. It does not want to dissolve the company. In that case, what they will have to do? They will have to apply for the dormant status. So first one is suo motu application for dormant company. So over here, company applies for status of a dormant company. And second one, ROC converts the company into dormant. Okay. Now in which case ROC will convert? Why will ROC step in into this? Suppose if any company has not filed its financial statements and annual return for 2 consecutive years, ROC may issue notice to such company, okay, and after issuing notice, if ROC is satisfied, it shall convert its status into a dormant company. So it is not always required that dormant status can be obtained by company, but sometimes when ROC thinks that this company is inactive, not filing its annual written financial statements, it may, by giving notice to the company, convert its status into a dormant company. So when company failed to file financial statements and annual return for 2 consecutive years, okay, in that case ROC by giving notice can convert itself into a dormant company. Is it clear? Now what is a procedure to be followed when company is making suo motu application for a dormant company? So let's see the procedure for conversion. What is the first step? First step, company which want to convert itself into a dormant company, it has to call the board meeting. Okay, in board meeting it has to discuss certain things as to, first of all, conversion. I will write it with the red so it will be easy for you. So what they will do in the meeting, first of all, discuss on the conversion part. Secondly, they shall approve notice of general meeting, because only board of directors cannot decide upon the dormancy. After that, they need to take the directors, shareholders approval. So fix day, date, time and venue for the general meeting. Fourth one, give authorization. Authorization can be given to a company secretary or the director. Okay. So this was your first step, calling of the board meeting and holding of the board meeting. After that, we have to issue 21 clear days notice. Okay. So for holding a general meeting, we need to give notice to the shareholders, issue notice of general meeting, 21 clear days notice is required. On the due date, we shall be holding our general meeting, and in that general meeting, we have to take the shareholders' approval, so by passing a special resolution. So over here, some different special resolution is there. Now what is this special resolution? We have to take approval of 3/4 in value. What do you have to take? Special resolution means for this dormant company only, we require approval of shareholders, okay, who are holding 3/4 of shares in value. Okay, 3/4 of shares in value means suppose the share capital of company is 1 lakh rupees. So we require approval of shareholder who are holding 75,000 rupees shares in the company. Generally, how do we pass a special resolution? Whoever is present in the meeting, out of that we take the special resolution. But this is a special one. Okay, we are converting your company into a dormant company. So, any shareholders who are holding 75,000 rupees share in company, in case of 1 lakh share capital, we will require that approval. I hope you understood how do we take this approval. After that, the next step, once general meeting is over, fourth point, now we are going to apply to ROC for the dormant application. Dormant application we give in form MSC1. Okay. So, apply to ROC for conversion into a dormant company. Okay. In which form we have to file? Form MSC1. Please remember name of the form. Form MSC1. This MSC1, till what date we have to file? Within 30 days of general meeting. Within 30 days of general meeting. And whenever we are passing a special resolution, we also file one more form, MGT 14, right? Also file form MGT 14. So both of this form shall be filed within 30 days of the general meeting. Is it clear everybody? Understanding what you are doing? Great. You can write along with me so that it will be very easy for you. Okay? Yeah. After that, fifth one, if our ROC is satisfied with the MSc1 form, it shall issue a certificate of conversion in MSc2. Okay? From that day, our company is a dormant company. Understood? And dormant company gets various privileges and the exemptions under this act. So next point, if ROC is satisfied, okay, it shall issue certificate of conversion in form MSc2. From this date, our company is a dormant company. Okay. So I hope the procedure is clear. We convened a board meeting, then general meeting, then 3/4 majority approval we took. After that, we filed MSc1 along with MGT 14, and if ROC is satisfied, it granted us certificate of conversion in MSc2. Is it clear? Great. Now, very important points to be remembered. For how many years a company can be a dormant company? Can it be for lifetime? The answer is no. Because as per ROC, if a company is not having business only, why to keep it active? right? We have a hope that we are going to start business in short term. That's why we are keeping the company live. But suppose that short term, we don't know when, ROC will not allow us to keep the company dormant. It will tell us to shut down the company. So a dormant company has to be only for 5 years. So company can be dormant company only and only for 5 years. So if we don't convert a status of dormant to active within 5 years, ROC may proceed for striking of the company. I hope this is clear. Okay. So a company can be dormant for only consecutive 5 years. Please remember this word, consecutive 5 years. Okay. If we don't convert, so within 5 years what we have to do, our dormant company is there, we have to convert this company into active company. If we don't do that, in case of a default, ROC may strike off our name of company from the register of company. ROC may strike off company from register of companies. Is it clear? Understood everyone? Great. Please note down, okay? If you don't note down, then you will not understand more of the procedure, and these notes are going to help you in last minute revision. Okay, I hope this is very clear. Now, I hope you've understood the procedure now, how to convert and for how many years a company can be a dormant company, what will happen in case of a default. Okay, so this is all in this video. Now we are going to see that in what cases ROC shall not grant you a dormant status. So there are certain conditions. If that condition is not complied with, ROC shall not grant a status of a dormant company. Okay, so what is the question? In what scenario ROC shall not grant a status of a dormant company? So the first scenario is whenever any inspection, inquiry or investigation is pending before any company. So whenever any inspection, inquiry, investigation is ordered and is taken up or carried out against the company, still it is pending, in that case they cannot apply for the dormant company. First they have to complete the inspection, investigation and inquiry. Only after that they can apply for the dormant company. I hope this is clear. Second one, any of the proceedings are initiated. Proceedings means case in the court of law. It can be any court of law. So in any court of law, the proceedings of the company are going on and they are still pending against the company. So till the time proceedings are not completed, the company cannot be converted into a dormant status. I hope this is clear. After that, if company has accepted the public deposits, that means your company is a eligible public company and it has accepted deposits from the public. So those deposits still outstanding is there. Okay, and in outstanding, company has made a default in payment of your deposit or interest. So first point, your company is eligible public company, it has accepted public deposits, on due date there is a default on repayment of deposit or its interest, ROC shall not grant such company as a dormant status. Okay, after that, if any company has outstanding loan, it may be secured or an unsecured loan. In this scenario also, ROC may not grant you a dormant status. But there is one exception to this rule. What is an exception? Suppose your outstanding loan is an unsecured loan. Which kind of loan it is? Outstanding loan is an unsecured loan. So there is no underlying asset to it. And if such company whose outstanding loan is an unsecured loan want to apply for the status of dormant company, if company obtains NOC from your unsecured creditors, with the help of that NOC, ROC may convert your status into a dormant company. Okay, so if company has an outstanding loan and company takes an NOC from the lender, and in this case, if ROC receives this NOC, then it may proceed for the dormant status. I hope this is clear. But is it possible for the secured loan? The answer is no. For secured loan, no dormant status. But for unsecured loan, with the help of NOC, can convert your status into a dormant company. Clear? But this document, that is NOC, has to be attached with your MSc 1 application. After that, there should be no dispute in the management or ownership of the company. So if there is any dispute among the board of directors or among the promoters, then also the company cannot be converted into a dormant company. So there is no dispute. You have to submit this certificate. So this certificate has to be accompanied in your MSc 1 application. So when this certificate is received by ROC, ROC may proceed for giving you MSc 2 certificate. Okay. When there is any outstanding compliances due means your statutory taxes are outstanding, your other dues, other duties are outstanding, ROC may not grant you a dormant status. First ROC will tell you to comply with all the dues, pay all the dues and then apply for the MSc 1. After that, if company is defaulted in paying workmen due only, they are not paying their workmen, not paying the salaries, can such company be converted into dormant status? The answer is no, cannot. In case your company is a listed company, if your company is a listed company, you cannot be converted into a dormant status. I hope you have understood where ROC may not give you a dormant status. Guys, this is very important from your case laws point of view. So let's revise one by one. Where investigation, inspection, inquiry is initiated, any of the proceedings of the company are pending before any court of the law, public deposits are outstanding and there is a default in repayment of that, there is outstanding loans, whether secured, unsecured. In case of unsecured, we can get NOC from the unsecured lenders, and this NOC, if we have attached with MSc 1, ROC may give us a dormant status, but for secured, it's not possible. After that, we have to give a certificate as to there is no dispute between management and ownership. They are perfectly fine. Okay, after that, if any outstanding dues, that is statutory dues or any taxes are pending, we will not be granted a dormant status. If workmen's dues are pending, no dormant status. If a company is a listed company, no dormant status. So I hope you have understood when a company cannot be a dormant company. Now we are going to start with what are the exemptions and benefits available to a dormant company. Very straightforward. This all benefits we have learned many times in part A. So what is the first benefit available? Dormant company has to convene only 2 board meetings in a year. Okay, each one in each half year. So our year starts from 1st of April. So first half is 1st April to 30th of September. Right? So one board meeting over here and second board meeting in the second half, which is from 1st of October to 31st of March. But very important, the gap between 2 consecutive board meetings should be minimum of 90 days. Okay, so this is our first exemption. Second exemption talks about dormant company is not required to make the cash flow statement. Not required. Okay, like other companies, dormant company is not required to attach cash flow along with its financial statement. Plus, the rotation of auditor provision is not applicable to the dormant company. Like if individual is there, it can hold auditorship only for 5 years. If firm is there, it can hold auditorship for 10 years. This is a rotation of auditor provision, but this is not applicable to the dormant company. Okay. Apart from that, dormant company has very low statutory compliances. So this is how it can save the cost, because it does not have any income, as it is not doing any business also. Okay. Apart from that, the other advantage to the promoter is that if it wants to hold any of the asset which it is going to use in future, or because of breakdown of industry, it is not in position to start the business, but it wants to retain the company, so it is also one of the advantage to the promoter. Also, your dormant status can be enjoyed for 5 consecutive years. So you have to become active company within 5 years. Otherwise, what will happen? Your company will be striked off by the ROC. So I hope you have understood what are the exemption privileges available to a dormant company. Now, what are the compliances required for the dormant company? In a dormant company, when it is a OPC, how many directors are required? How many shareholders are required? Minimum one director, okay, and minimum one shareholder, okay. In case of a private limited company, minimum 2 shareholders and minimum 2 directors. In case of a public limited company, minimum 7 shareholders and 3 directors. This is compulsory requirement, just like the other company. Yes. So when you are a dormant company, you will not get any exemptions as far as directors and shareholders are concerned. Second compliance which company needs to do is file the return of dormant company. Dormant company need not file its financial statements and annual return. Okay, it only has to file one form, that is return of a dormant company. This is the obligations of the company. Every year company has to file this dormant company form in MSC 3. MSC 1 is application for dormant, MSC 2 is certificate received from ROC, and MSC 3 is return of a dormant company. So in this MSc 3, what will be written? What you have done in the entire year. So this will be certified by a statutory auditor of company, and it is to be filed within 30 days of closure of the financial year. Okay, so it will be audited by whom? Chartered accountant, and it is to be filed within 30 days from end of financial year. Remember, form MSc 3. Also, dormant company need not disclose your cash flow statement. So it is not mandatory to make cash flow statement for them. They have to hold at least 2 board meetings in a year, one in each half with minimum gap of 90 days in 2 consecutive board meetings. Rotation of auditor is not applicable to the dormant company. Okay, and company has to file all the written allotment of share, director, everything. Apart from this, all other provision for dormant company remains one and the same. I hope this is very clear. So we have understood what are the exemptions available and what are the obligations of a dormant company. Now we are going to see how to convert a dormant into active. I hope you are enjoying this chapter. I told you part C is very interesting. We are also going to enjoy chapter 20 and 21. Okay, and this chapter is so small that we are into our last part of this chapter. Okay, so till now we have seen the benefits, the obligations of a dormant company. Now we are going to see, when we are a dormant company now, how to get converted into an active company, because we cannot be dormant company for lifetime. And we also know that as per section 455, a company can be dormant company only for 5 years. So within 5 years, we have to make provisions to start our business and convert our company into an active company. Otherwise, what will our ROC do? Strike off the name of company from the register of companies. Okay, so Section 455 read with Rule 8 of Companies Miscellaneous Act, it provides for conversion of active from the dormant company. This application of active from the dormant company has to be made within end of 5 consecutive years. So we have to make before that 5 years. If we don't do that, then ROC may remove our name or strike off our name from register of companies. Okay. Plus, remember this very carefully. Whenever we have made application for the dormant status, okay, we have made application for the dormant status, they give us various provisions, various conditions for that. So we have to comply with the conditions of a dormant company. If we don't comply with any of the conditions of the dormant company, within 7 days, within 7 days of default, we have to file application for the conversion into an active company. I will tell you how it happens. See, right now we are a dormant company, right? Right now we are a dormant company. So we have to file MSc 3, that is return of a dormant company. We have to conduct 2 board meetings. So all the conditions or obligations are there. I can call it as a conditions or obligations. Company has to comply. If in compliance of these conditions or obligation, company makes any default. So when this default is made, within 7 days of default, okay, within 7 days of default, company has to file an application for conversion into a active company. So file application for conversion into which company? Active company. Is it clear? So your application for active company, it's filed in 2 circumstances. One, when company wants to convert into active company, and second, when you don't comply with any conditions of the dormant company. So I hope you have understood this. So we have to file application for obtaining a status of active company within 7 days of default. Okay. Now ROC may remove our name from list of dormant companies. So ROC may remove our name from list of dormant companies if ROC feels that we have contravened any of the conditions of dormant status. Okay, so when ROC feels that we have contravened any conditions of dormant status, that means we may be active company, maybe we are doing significant accounting transaction, and ROC makes reasonable inquiry. After that, gives opportunity of being heard to the company. After that, it may remove our name from list of dormant company and put it into the active company. Clear with this? Great. Now we are going to see what is the procedure to obtain an active status. Okay. For dormant, we filed application in MSc 1. Now we are going to file application for conversion of dormant company into active company in MSc 4. Which form is there? MSc 4 is to be filed for conversion of dormant company into an active company. Okay. So MSc 4 will be filed with the ROC. Along with MSc 4, we have to file form MSc 3 ending that particular financial year. Also, we should make sure all MSc 3s are duly filed. If we have any default in filing MSc 3, our application will not be accepted. Okay, and if ROC is satisfied with our application in MSc 4, it shall issue a certificate of an active company in MSc 5. So once we receive MSc 5, from that day we are an active company. Okay, so we can operate all the things, and whatever benefits exemption available to dormant company was there, it will not be available anymore. I hope this is very clear. Great. Now ROC may suo motu change the status from dormant to active. In which scenario ROC can do that? Very important. In 2 scenarios it can do. Okay, if company does any default, if company does any default in complying with any obligations or conditions of dormant company, in that case company has to apply for application to convert itself into active company within 7 days of default. Okay, within 7 days of default it has to apply, the first case. Second case, if ROC thinks that company is active or company is doing some SAT or it is not complying with any condition or obligation for a dormant status, what will ROC do? Number one, it can initiate an inquiry. Inquiry under section 206 of Companies Act 2013. After that, give reasonable opportunity of being heard to the company. After that, if ROC is satisfied that yes, company has done default or it is operative, it may remove the name of dormant status of company from that list and put it into the active company list. Okay, so let us underline, when ROC has reasonable cause to believe that any company which is registered as dormant within its jurisdiction, it is functioning in any manner, directly or indirectly, it is affecting the status of a dormant company. So it is pretending to be dormant but actually it is not dormant. So ROC may initiate proceedings of inquiry under section 206, give opportunity of being heard, and after that if ROC thinks that company has done the default, it can remove the name from list of dormant company and treat that company as an active company. Okay, so these are the two scenarios where ROC will take action for conversion of dormant into active. So I hope you have understood the chapter. Very easy chapter, very scoring chapter. Now let's start with solving your question answer. Chapter 19 was very easy. Yes. So Cute Garments has recently obtained the status of a dormant company. Board seeks your advice about required compliance in respect of minimum number of director. Simple. For OPC 1, for private 2 and for public 3. Okay. Requirement of written filing. They don't need to file financial statements and annual return, but they'll be required to file the return of dormant company in MSC 3. Right. Then meeting of board of director. 2 board meetings minimum. Okay, each and every half with minimum gap of 90 days. So easy it was. Next, dormant status is an excellent tool for keeping assets for the future usage. Okay, it is an excellent tool. Why? Because if any property we are getting at lesser price but we cannot start business immediately, we can purchase that by incorporating company. Thereby we reduce, okay, or we save our transfer fees. Secondly, ROC shall not strike you off. Okay, if you are a dormant company for a period of 5 years. So that's why it's an excellent tool. Okay. Then Preeta has recently become director of company. She wants to know about active inactive status in MCA. Explain a concept of inactive company, referring relevant provisions of company law. Also brief her what are the circumstances when company can obtain a dormant status. You have to write what is a definition of an inactive company. Very simple it was. Now we are going to start with chapter number 20, which is chapter number 2 of your part C. Chapter number 19 was very easy. Even this chapter is equally interesting but little lengthy. So the name of the chapter is striking off the name of company LLP and restoration of the same. So in this we are going to learn from section 248 to 252. Also we are going to learn certain sections from the LLP. So in this chapter we are going to learn in what circumstances ROC can strike off the name of company, strike off the name of LLP. Also in certain circumstances company or LLP can suo motu strike off their name. Okay, so when they don't want to go for winding up procedure, certain kind of companies can directly strike off the name, and that is a fast track for winding up of any company. Also, when ROC has invalidly strike off the name. So now company wants to restore its name. So authority is not that with ROC, but whenever any company strike off is done, the authority is only with the NCLT to revive such company or LLP. So this is what we are going to learn in this chapter. So let's start. So as I told you guys, the name is strike off and restoration of name of company and LLP. If you will ask me about the weightage, all your three chapters, that is 19, 20, 21, equally important. We cannot give you any particular weightage. Why? The reason is, in one particular attempt, this chapter was asked for 11 marks. In one particular attempt, this was asked for only 5 marks. So this is how in one attempt they increase some chapters weightage and in the other they reduce. That's why learning these 3 chapters for 25 marks becomes equally important. So in this chapter we are going to learn about the strike off of the company. Strike off can be done by 2 ways. ROC is striking off or company wants to strike off. Okay, and striking off of company and LLP. Also we are going to learn how to restore the name of company or LLP when it is striked off. Okay, so let's start with the act. As I told you, we are going to learn from section number 248 to section 252 of Companies Act 2013. Okay, now when company is incorporated, let me make you understand over here. Whenever company is incorporated, okay, ROC register the name of company in one register called as Register of Companies. Okay, ROC maintains a register called as Registers of Company. So whenever it gives COI to any company, it inserts the name in this. Okay. Now, as per section 248, when company does not comply with any condition, ROC may strike off the name of company from this register. So what is the meaning of a striking off over here? Strike off means what? Over here, striking off means removal of name of company, removal of name of company from register of company, from register of company maintained by ROC, maintained by ROC. So when ROC removes the name, strike off the name, it means it is striking off or removal of name of company's name from the register of company. What is the consequence of this? Or what is the effect of this? The effect of this is your company is temporarily shut down. Okay, so this amounts to temporary closure of company. Why I call it as a temporary closure? I call it as a temporary closure because it can be revived. I call it as a temporary closure because company which is striked off can be revived. Understood? That's why striking off means temporary closure of the company because it can be revived. And who has authority to revive? Only and only your NCLT. Okay? Only and only your NCLT. So basically, what we are going to learn, sections 248 to section 252 we are going to learn. Along with that, we are going to learn about strike off. I hope you have understood what is a strike off. So strike off can be of two entities. It can be of company. It can be of LLP. So we are going to learn strike off of both LLP and company. Along with that, for LLP and company, The strike off can be done in two ways. Strike off by ROC and striking off suo moto. Suo moto means company itself. Okay, so strike off are of two kinds, strike off of company LLP, and both of the strike off can happen by ROC or by suo moto. Okay, this is what we are going to learn. Along with that, we are going to learn once strike off is there. I told you we can restore the company also. We can restore the company and LLP, but who has authority to restore? Only and only NCLT. So when any company wants to restore itself, it has to make application to NCLT. Who can strike off? ROC. Is it clear? This is a road map I have showed you. Okay, now let's underline few important points in our notes. Then we will end the video and start with the concept from the next video. So, on striking off the name of company or LLP, it is temporarily removed from the register. It can be restored on making application to whom? The NCLT. Very clear with this. Now let's see the technical part. Sections which are important are 248 to 252, read with the rules, that is companies removal of names from Register of Companies Rules 2016. Is it clear? Understood? So when any company is not operative, if ROC thinks fit, after opportunity of being heard, it can strike off. Also, if company wants to make suo moto application for winding up the company and it is eligible to wind up as per section 248, it can also make the application to the ROC. Okay, so there are two ways of striking off as I discussed with you. One is by ROC on suo moto basis. Over here ROC wants to strike off the name. Okay, and the second scenario, application is made by company to strike off its name. So now let's begin with our first kind of application, that is striking off. So in this video we are going to learn strike off of company by ROC suo moto. So first of all, let's understand in which circumstances ROC shall start with the strike off process of the company. For your kind information, when these rules came in 2016, in 2017, ROC had striked off almost 3 lakh companies. So companies which are shell companies, which are just made for sake of a name, for giving effect to a particular transaction and actually no business is there. ROC would shut down such companies. So over 3 lakh companies were striked off in 2017. Okay, so now let's see which scenario, what circumstances are there where ROC has to step forward and tell the company we are going to strike you. Okay, so let's understand the circumstances first. Before that, I would like to tell you the section number. Section number is 248 subsection 1. 248 subsection 1 deals with striking off of company by ROC suo moto. So what are the circumstances where ROC will himself go for striking off the company? The first one, the company was not able to start its business within 1 year of incorporation. So company was incorporated, 1 year is over, till now not able to do or start its business. Okay, so what is the first scenario? Within 1 year of incorporation, failed to start business. Okay, within 1 year of incorporation, failed to start the business. In this scenario, ROC can suo moto apply for striking off. Okay, second, if company is not carrying on business for consecutive 2 years. Now how this first point and second point is different? Once incorporation was done, company had started with the business. Okay, it is doing business, but after a few years it has stopped doing business and now 2 years has done, still they have not started with the business. So in such scenario, what they have to do? Actually, they would have to apply for the dormant company, but they defaulted. So when any company defaults in application of dormant company and their business is not on for at least 2 years, ROC may proceed for striking off. Okay? Yes. So company not carrying on business since immediately preceding 2 financial years and also defaulted in making dormant company application. So it did not file any application for conversion into dormant company, and since 2 years it is not doing any business, ROC may proceed for striking off. Okay, this was the second scenario. Now third scenario. I hope you remember in chapter number 2, we had learned something called as form INC 20A, that is commencement of business certificate, right? In that we were doing two verification. One, subscription money is received, and second, verification of registered office. So if company has defaulted in subscription money, so company did not receive subscription money. Also, it defaulted in filing form INC 20A. So in that scenario also ROC may proceed for the striking off. So what is the next one? Failed to receive subscription money and filing of form INC 20A. Please remember the name of the form, INC 20A. Okay, till when? Within 180 days from incorporation. Within 180 days from incorporation, it failed to receive the subscription money, also did not file form INC 20A. In this scenario also ROC may start for the striking off. So till now we have seen 3 scenarios. Now we are going for the fourth circumstances. ROC has come for the physical verification. After physical verification, ROC is of opinion that this company needs to be striked off as it is not carrying on any business. Okay, so in that case also ROC may start the striking off. So the fourth one is physical verification. ROC is of opinion to strike off company. Okay, so these are the 4 scenarios where ROC may start the striking off procedure. So let's revise the 4 scenarios under section 248 subsection 1, which are the 4 circumstances where ROC will start the striking off. First, since incorporation 1 year has been elapsed and company was not able to start its business, or company had started business after incorporation, but due to some reason it stopped its business, and now it's been 2 years it has not started the business. So company is not doing business from 2 years. In this scenario they have not made dormant application also. Third one, it failed to receive the subscription money and also failed to file for INC 20A within 180 days of incorporation. Fourth, ROC on physical verification, it was of opinion that company needs to be striked off as it is not carrying on any activities. So please remember these 4 circumstances. Now we are going to see what is a procedure. Okay, what is a procedure for striking off company by ROC. Okay, this procedure is in detail. We are going to learn this in detail, and it is very compulsory in exams. They do ask you the procedure. Okay, so let's begin. Which section is this? Always remember section 248 subsection 1. In that first step, whenever for any reason ROC feels that the company needs to be striked off, okay, it first of all it needs to give notice to the company, and in that notice ROC has to give a reason. Out of that four circumstances, any one has to be there. Okay, so ROC should give the reasons that why it is striking off the company. Okay, so first step, ROC shall provide notice, or we can write issue notice, that's a better word. So ROC shall issue notice to the company. Okay, this notice is to be given in which format? This notice is to be given in format STK1. Please remember which format is there? STK1. So ROC shall issue notice in format STK1 to the company. Company means where it will issue. It will issue notice at the registered office of the company. Okay. Also to director's address. To all directors registered address. Okay. This will be sent by post. Okay. This STK1 can also be sent through email. Okay. So email to company and email to all the directors. Understood? So STK1 can be sent by the ROC to company at their address, or they can also send it via email. Okay, please remember this. And it becomes very important to keep the acknowledgement. Okay, so that whenever company says that we did not receive any notice, ROC should be of position to show, see boss, we had received your acknowledgement. That means you have received our email and you still ignored it. I hope this is clear. So STK1 will be sent to the company, also to all the directors by post or by email. Is it clear, the first point? Very good. Now, why do we receive this notice? Because whenever ROC want to strike off, before that a reasonable opportunity of being heard should be given. Yes. So for this reason only, ROC is intimating the company that we are about to strike off. If you don't want to strike off your company, tell us reason why we should not strike off. Understood? So once notice is received by the company, then second, company should reply. Okay. Okay, let us first write what is written in this notice. In this notice, the write as following: ROC shall strike off name of your company, okay, for so and so reasons. Okay, you have to write the reasons why ROC feels that. Then a reasonable opportunity is given to company. Reasonable opportunity of being heard is given to company, okay, and it shall warn that the company shall be striked off. Company shall be striked off if we do not hear anything within 30 days. Within 30 days. So this is a deadline and this is what they write in that STK1. Okay, so ROC is giving intimation to company we are about to strike off. If you want to save your company, give us a reason why we should not strike off within how many days? 30 days of STK1. Is it clear? Yes, 30 days of, remember, receipt of STK1. So in the second, it will be very important for company to give reasons in writing if they want to really save the company. If they don't want to save the company can go ahead. Okay. So second step, company should give representation. What do we call it? Remember the word representation. Okay. Within 30 days. 30 days of notice. And this is in writing. Company has to give representations in writing. But if we fail to do so in 30 days, ROC will proceed for striking of the name. Okay. So once company gives representation to ROC in writing, two scenarios may come up. One, ROC is satisfied with our representation. So when it is satisfied, it shall not strike off. It shall not strike off. When ROC is not satisfied with our representation, it shall proceed to strike off. It shall proceed to strike off. Is it clear? So till now what happened? ROC issued notice in STK1. Company replied within 30 days. Okay, ROC if satisfied, it will not strike off. Not satisfied, it will proceed for strike off. If company does not apply within 30 days, then the first step will not be there. ROC is not satisfied and it will proceed for the striking off. Is it clear? Great. Now we are going to the fourth point. There is one case law on this. Okay, over here there is a case law. We will discuss that from our notes. There is a case law of International Security Printers Private Limited versus ROC Delhi. This is a 2017 August case. In this case, what had happened? ROC, okay, over here, as I told you, lot of companies were striked off by ROC. Okay, so in Delhi, ROC had struck off almost 6,000 companies. So 6,000 companies were striked off without giving any notice to them. STK1 is compulsory, but ROC did not give notice to them. Neither ROC adhered to any legal procedure. So ROC did not give them any notice and did not give opportunity of being heard to the company. This was contention given by International Security Printers. Actually what had happened, their company was running, but ROC had striked off without following the procedure. Understood? So how did they strike off? Without giving STK1. Okay. Also in official gazette they did not give any intimation. Also, without adhering to the procedure, it went and striked off the company. So, international printers, okay, international security printers, they had put an impugned action is vitiated. What did they claim? This action is vitiated and it is gross violation of principles of natural justice. So, company was strike off without giving opportunity of being heard. Okay, so in this case, what was a decision of a honorable bench? Your NCLT is there. So decision of honorable bench was as follows. Please remember. Principle of natural justice has to be followed. So over here, ROC failed to prove the allegation that proper notice was given. So ROC was not able to prove because it did not give any notice only. Understood? So it did not comply with mandatory provisions of 252.456 where there is a prerequisite for striking of the name of the company. So in this case, there was absence of action of respondent, and this was found arbitrary, illegal, against principle of natural justice. So their petition was accepted. Okay, so over here international printer won the case and they were revived because ROC did not follow the procedure. In question, in exam you get a question, is it compulsory for ROC to follow procedure of striking off? The answer is yes, and you have to write this case. Which case? International Security Printers Private Limited versus ROC Delhi. Okay, so if ROC does not follow the procedure, if they do not give STK1, do not give opportunity of being heard, this is violation of principles of natural justice and your petition may be accepted by the NCLT. Is it clear, children? Please remember the case. Okay, yes. Next name. Once ROC is satisfied with your representation, it will not strike off. But if ROC is not satisfied, it will proceed for the strike off. So how to proceed with the strike off? What it will do? It will publish the name of company for the removal, that they will give a final notification, and this will be published in 3 places. Where it will be published, please remember, first of all it will be published in the official gazette. Okay, second, it will be published on the website of MCA, and third one, it will be published in 2 newspapers. Okay, it will be published in 2 newspapers, one English newspaper operating in that state, another vernacular. Okay, this notice which is published in newspaper will be in format STK5A. Please remember, newspaper advertisement will be in STK5A, and these notices which are published over here, it will be in form STK5. Is it clear, guys? Understood? So ROC will publish that we are going to strike off the name of these companies, and if anybody has any objection, come to me within 30 days, otherwise we are going to strike off the name. So this is a format STK5, newspaper advertisement format is STK5A, and they have to publish in official gazette, website, and 2 newspapers, one English and one vernacular. Is it clear, guys? Okay. After that, 5th one. So I will write for you over here. This notification is given. If any objection is there, raise before ROC within 30 days. Please remember, within 30 days. Okay, clear with this? Great. So this is your STK5 and STK5A. After that, the 5th step. If ROC, okay, is satisfied, after that 5th step, now ROC will also intimate the other authorities like income tax authority. Wherever your company is regulated, suppose your company was a banking company, then other authorities were required to intimate your RBI. If it was an insurance company, then we need to intimate the IRDA. Okay, so next step is ROC shall give notice to other authorities. Okay, other authorities means income tax department or IRDA or RBI, etc. Okay, because they should know that company which is regulated by them is going to get striked off. Okay, so if their claims are there, they can satisfy their claims fully. This was your 5th one. Okay, after that, ROC shall wait for 30 days, as I told you, in STK5 and STK5A. So once 30 days is done, after 30 days, what is the scenario now? ROC may receive objections and may not receive objections. So two scenarios, it may receive the objections or no objections are received. So first we will go with, if ROC has received the objections, ROC shall call for hearing. Both the parties shall be heard. After that, on the basis of the decision, ROC shall decide whether to strike off or not to strike off. But when no objections are there, it shall directly proceed for the striking off. Is it clear? Understood the sixth step? Okay. Now we are going to the seventh step. This is a final step. Okay. Now finally ROC shall intimate that we are about to close you. This is intimation given to the company, final one. Whatever formalities you want to do, closing of bank account, remove the cash, pay off your employees, whatever you do, you will do it. Because after this days, your company will be closed. You will not be able to do any other formalities. Okay. So ROC shall intimate the company. What it will intimate the company? To square off all the contracts. To square off all the contracts, rights and liabilities. Okay, but listen to this. It will also take an undertaking from the company. Even though company striked off, this is temporary closure. Understood? So closure of the company or striking of the company does not relieve with liability. So if some liability is there, after striking off also the company can be restored and it will be duty of the directors of company to pay off that liability. So striking off does not relieve the company from its liability. Okay, also ROC shall take an undertaking. What undertaking? That it will make sure that company's assets are enough to pay off the liabilities, and liabilities shall be valid even after strike off. Okay. So the company is basically a solvent company. Now what will happen if company is an insolvent company? Then striking off cannot be done as per section 248 to 252. It has to go by IBC. So when liabilities are more, assets are less, company or ROC cannot strike off as per the company law, but they have to follow the insolvency bankruptcy code for that. Is it clear? Understood? So even though your company is striked off, still your liabilities will be alive and your company's asset should be enough to pay off all your liabilities. This was your point number 7. After that, last one, 8th point. Now ROC shall publish the notice of strike off in the official gazette. So the moment the notice is published, in that it is written the company shall stand strike off from this day. So that is a day when your company is closed down. Okay. Now ROC shall publish notice of strike off. Okay, in which format it is going to issue this notice? Please remember STK 7. STK 7 is a final notice of closure. Okay, and this is to be, this final notice to be published in the official gazette. Okay, now when this final notice is given in the official gazette, it will be deemed that company is striked off. Okay, Understood guys, all these steps? I hope it was very easy, not so difficult, right? So let's revise all these steps one more time. What did we do? Yes. So the very first step, ROC shall issue STK1 notice to the company, and in that it will write that if you don't want your company to be striked off, please revert us within 30 days. Okay. After that, company has to give written representation within 30 days. If ROC is satisfied with the representation, it will not strike off. If it is not satisfied, it will proceed for the strike off. Then ROC shall publish name of company in the official gazette on the website of MCA and in the two newspapers, one English and vernacular. This notice will be in STK 5. Newspaper advertisement to be in STK 5A, that we are about to strike off this name, this company. If anybody has any objection, please come to ROC within 30 days. Okay. Also, ROC shall send this notice to other regulatories who are regulating the company. Once 30 days are over, it will wait for 30 days. After 30 days, if objections are received, it shall call for hearing. If objections are not received, then it shall proceed for the strike off. Now the final intimation shall be given to the company that please square off all your liabilities, all your contracts, because we are about to strike off your name. And also take undertaking from company that company is a solvent company, able to pay off all its liabilities, so assets are enough. So even though company is striked off, okay, the liability would not affect, it will be alive. So after this undertaking is received, ROC shall publish the final notice in STK 7 in the official gazette. Once this notification appears, your company is deemed to be strike off. I hope you understood the entire procedure. Okay. Now in this video we are going to learn when a company wants to voluntarily wound up. Okay, it wants to apply for the striking off. Then what is the procedure? Now listen very carefully. When the company has enough assets, okay, when company has enough assets and when they comply with the conditions and when they are eligible companies who can apply for the strike off, then only company can apply for striking off. Striking off is removal of company's name, means the company is getting wound up. Now you might have heard about winding up by the NCLTs, right? So those is a lengthy procedure. Then why and which companies can take this shortcut provision, we will watch in the next video. But in this video we are going to learn the eligible companies which can file application to ROC for striking off. What is a procedure to be followed by them? Okay, so when company don't want to continue with the business and it's an eligible company who can file application under this section, that is 248 subsection 2, it may follow this procedure and give application for winding up, okay, for the company. Understood? Even this means a temporary closure. When any person, okay, who is interested, it wants to restore the name of the company, even they can apply to the NCLT. Okay, so now we will see the procedure for voluntary striking off by the company. The very first step, now company wants to wind up, so it needs to first call the board meeting by giving 7 days notice and then hold the board meeting. So call board meeting and hold the board meeting. Now in this board meeting, what all things they are going to do? First, pass a board resolution for the striking off. Second, they have to do the general meeting compliances, that is approval of general meeting notice. Also, they need to fix day, date, place and venue of the general meeting, and the fourth one is authorization. Okay, they have to authorize any director or a company secretary. After that, they have to issue notice of general meeting by 21 clear days. Okay. Then on the due date, they shall be holding general meeting, and in this they need to pass a special resolution. They need to pass special resolution. Okay. So once they pass a special resolution, which form we need to file? MGT 14, right? So file form MGT 14 with ROC within 30 days of general meeting. I hope this was very clear. These are the basic rules. Now when you want to wind up, you have to extinguish all your liabilities. Okay, so company has to extinguish all its liabilities, contracts, etc. So the balance sheet of the company should be very clear, it should be nil. Only share capital part should be standing, everything should be zero. Only such companies can apply for the voluntary strike off. I hope this is very clear. Understood? So balance sheet should be nil. Okay? Yes, extinguishing liability means everything should be zero. This was point number 5. Now point number 6. Now we have to make preparation of documents, right? Preparing documents for strike off. We need to file certain documents with the ROC because over here company is applying for striking off, correct? So they need certain documents to be filed. So it shall require indemnity bond, okay, indemnity bond in the format STK3. Please remember, indemnity bond is to be filed and made in format STK3. Okay. Second, they need to make affidavits. Affidavit by every director. Each and every director of the company will be making the affidavit in format STK4. So please remember, STK3 is indemnity bond, STK4 is your affidavit. Okay. Now this indemnity bond affidavit, both of them has to be notarized. It has to be notarized. So when our director is a foreign director, it needs to be notarized by the foreign ambassador. Clear with this? Understood? Yes. After that, indemnity bond is done, affidavit is done, everybody understood. Then we have to make statement of asset and liabilities. Statement of asset and liability. This is basically nothing but a balance sheet. Everything should be nil. Everything should be nil. Like this is your statement of asset and liability. This is your liability. This is your asset. Everything should be nil. Except of the share capital, nothing should be there. Okay. And this statement of asset and liability should not be older than 30 days of application. Okay. This should not be older than 30 days from application. Okay, so if you are applying today, before 30 days only you have to make. You cannot make more than that. I hope this is clear because beyond 30 days it is not valid. So first we made indemnity STK3, affidavit STK4 and statement of asset and liabilities to be made. Apart from that, we will require NOC from various authorities or other regulatories. Why do we require NOC? Because if RBI is governing us, we have to take NOC from RBI. If IRDA is governing us, we have to take NOC from IRDA. Okay, so this is a NOC from other regulatories that they don't have any problem if we are striking off our company. Okay, so we made the application, indemnity bond, affidavit, statement of asset liability and NOC. Now we are going to the next point, filing of application with the ROC. So when ROC striked off the company, it sent notice in STK 1. When we are applying, company is applying for striking off, it shall give application for striking off in STK 2. So voluntary striking of STK 2 and ROC striking of STK 1. Please remember. Okay. So company shall file application for strike off. In which form? Form STK2. Okay, it is to be filed with whom? With the ROC. In this STK2, it shall be signed by the director, along with that any professional. Okay, it can be a practicing CS or practicing chartered accountant or cost management accountant. So directors sign, along with that PCS or chartered accountant or cost management accountant signature. This is your STK2. In STK2, we have to attach all the documents which we have made, that is indemnity bond, affidavit, NOC, statement of assets and liabilities. Is it clear? Great. Now next step, eighth one. Once ROC receives our application, it publishes this in the MCA website, 2 newspapers and official gazette. Same like what ROC did in the suo motu application, right? So ROC shall publish closure notice of company. Okay, where it is going to publish? It is going to publish in the official gazette first of all. Okay, then also on the website. Okay, and the third one in 2 newspapers. One will be English, another one will be vernacular. Okay, and this should be given. Why? Because ROC will tell in the notice, if anybody has any objection, they can intimate us within 30 days. Okay, in case of objections raised within 30 days. Clear with this? This notice is given in form, please remember, STK6. The earlier one was STK5 and newspaper STK5A. Is it clear? Understood? Great. Okay. After that, ninth point, like we had seen in the suo motu obligation, over here also ROC shall intimate the other authorities. So, okay, so next point is ROC shall intimate other regulatories. Other regulatories means what? If company is governed by SEBI, then it will intimate SEBI. If company is governed by IRDA, then it shall intimate IRDA. In case of banking, NBFC, it shall intimate the RBI. So it will give intimation to the other regulatories that company is getting striked off by the voluntary application. If you have any objections, please give us by 30 days. Okay. So after that, the next one, same like the earlier procedure, ROC shall wait for 30 days. Okay. So after 30 days, what shall happen? ROC may receive objections, may not receive objections. So it receives objections, and second, no objections received. When no objections are received, straightforward it shall proceed for strike off. Okay. proceed for the strike off. But if the objections are received, okay, it shall order hearing. It shall order the hearing. When hearing is done, I will continue over here. Okay, when hearing is done and the decision comes in company's favor, okay, then ROC shall proceed for strike off. If it is not in company's favor, it is opponent's favor. It is in opponent's favor. Okay, in this case, ROC shall reject your strike off application. It shall reject strike off application. Clear with this? Understood? Yes, so this was your 10th step. Now we are going to the 11th step. Now the final notice will be there. In which case final notice? The first case. Hearing was done and it came in company's favor or were there no objections. Okay, so ROC is going to proceed for the final strike off notice. So over here ROC shall issue final notice of strike off. Okay, strike off notice is in the same format like we said in the suo motu application. The format is form STK7. Please remember the form number. Form number is STK7. This will be published in the official gazette. Okay. So once this is published in the official gazette, it is deemed that company strike off. I hope this is very clear. Okay, so don't you think it's a similar kind of procedure? Yes, but in earlier one, ROC initiated. In this procedure, company has initiated. Now we are going to see in what type of circumstances company cannot apply for the strike off, or in what type of circumstances ROC cannot strike off the name of the company. So this becomes very important to remember. Why it is very important to remember? This is because over here ROC cannot strike off name of such company directly. Even companies cannot apply for the strike off. Okay, so please remember, important from the case laws perspective. Now, the first one, listed companies. Everybody knows what are listed companies. The shares of the companies are listed and traded on the stock exchange. Such listed company cannot wind up themselves by filing the strike off application, or even ROC cannot remove name of such companies. Okay, they have to go by the detailed procedure of winding up, which we'll be learning in chapter number 21. So listed company cannot apply for the strike off, please remember. After that, second type of company we have where charges are pending for satisfaction. You all might have heard about or learnt about what are charges in your Companies Act 2013. What are charges? Whenever company takes loan, basically a secured loan, it creates charge on asset of the company. So once charge is created, the charge needs to satisfy. Yes, but if any company do not satisfy the charge, in that case what will happen? In that case, company cannot file the application for strike off. Neither ROC can strike off the name of such company from register of companies. I hope this is very clear. After that, whose application for compounding is pending. Compounding is basically for the penalties. Okay, so when company has applied for compounding application, in that case also such companies cannot be removed by the striking off. Apart from that, next type of company is a vanishing company. Now what is a vanishing company? The definition is given right over here. The first requirement, let's mark it. Company is registered under the Companies Act, first of all. Second, company is listed on the stock exchange but has failed to file the return with ROC and stock exchange for consecutive 2 years. Okay, so it's registered under this act. Secondly, it's a listed company. Third, it failed to file its annual return and financial report with ROC and stock exchange for consecutive 2 years. Now third one, company has to maintain the registered office, yes, and it has to do the verification of the registered office. This we have learned in chapter number 2. But the verification company has done, but company has done fraud with the ROC. How? It is not maintaining the registered office whose address is given to ROC. So the address provided to the ROC is fake. Okay, so what is the third one? Company is not maintaining the registered office at address which is notified to the ROC. So this is a third condition. After that, the fourth one, none of its directors are traceable. ROC tries to contact the directors. The contact numbers are given, email IDs are given. The last chance is they send the post to the registered office. But company is not maintaining registered office at the given address. Neither email is available nor the contact number of directors are available. Such companies are called as vanishing companies. What do you call such companies? Vanishing companies. Is it clear? So 4 important points to be remembered. First, company is registered under Companies Act. It's a listed company but defaulting in filing of the annual return and financial statement with ROC and stock exchange for 2 consecutive years. The third one, company is not maintaining the registered office of which address is given to the ROC. And fourth, directors are not traceable. So all this 4 amounts to vanishing companies. So such vanishing companies cannot be striked off by just this section. Is it clear? Great. After that, company has been delisted. You know what is a delisting? Listing means shares are listed and traded. Delisting can be for 2 reasons. First, company has not complied with LODR or other regulations. Second, company is suo motu doing delisting. If it is suo motu doing delisting, no problem. But when any company has defaulted any of the provisions of the stock exchange or SEBI, because of that, SEBI has delisted its shares. So delisting of share is done due to non-compliance. Okay, it is done due to non-compliance of LODR regulation. It may be listing agreement, it may be listing obligations. Okay, so such companies cannot be striked off under this provisions. Apart from that, whenever company's inspection or investigation is ordered, okay, investigation is ordered, it is carried on and it is pending. So prosecutions are pending. I will explain you. Investigation and inspection was ordered. Okay, it was carried out. Because of that, many defaults against the company came up. So when defaults came up, the creditors, the ROC, they filed the suits in the NCLT. Okay, so these are called as prosecutions arising out of investigation and the inspection. Got it? Prosecutions arising out of investigation and inspection. These prosecutions are pending. Okay, understood? So I'll repeat one more time. Whenever any investigation or inspection is carried on, because of that, some prosecutions have been filed and those prosecutions are pending, it cannot be strike off till the time we complete those prosecutions. Understood? Great. After that, companies which has accepted the deposits, those are outstanding and company has made default in repayment of the same. In that case, what will happen? No strike off as per this provisions. Next, there is a order passed against company under section 234 of Companies Act 1956 or 206-207. This all are the inquiry sections. So ROC has issued order that we need to do inquiry in the affairs of the company. And in the case they are doing inquiry, various prosecutions are filed. So when these prosecutions are filed and they are still pending, so prosecutions arising out of inquiry, scrutiny is pending before the court of law. So all these grounds are there, then ROC cannot remove name of such company, neither company can apply for the strike off. Please remember, very important, let us revise one more time. Listed companies, then section 8 company, yeah, I missed that. Yes, even section 8 company cannot be directly wound up by striking off, it needs to go by detailed winding up procedure. Okay, so listed company, section 8 company, where charges satisfactions are pending, where compounding application is pending. Vanishing company is important, 4 points in that, please remember. In case of a delisting of shares due to non-compliance of listing agreement or listing obligations or any other law, then inspection investigation is carried out, prosecutions are filed and those prosecutions are pending. Company has accepted public deposits, there is default in repayment of the same. The last one, inquiry was ordered. On the basis of inquiry, prosecutions are filed and prosecutions are pending. In that case, company's name cannot be removed under this provisions. Neither ROC can remove nor company can file application. Now we are going to see in what circumstances company cannot apply for the strike off. Yes, I am talking about the voluntary application which we have seen. Yes, STK2. Whenever company wants to strike off itself, that means get wind up, so it has one shortcut that without going to the NCLT, if it is eligible company, it can file application under STK2. But which all companies cannot file STK2, we are going to see that. This is very, very important from your case laws point of view. Okay, the very first thing, whenever company has done any of these acts in its previous 3 months, so company has done any of these acts in previous 3 months, it cannot apply STK2. Please remember, cannot file or apply for STK2. Okay, so now in previous 3 months, if company has changed its name, if company has changed its name, company cannot apply for the STK2. Okay, I'll repeat one more time. In previous 3 months, if company has changed its name, it cannot apply for the STK2. Or if company has shifted its registered office from one state to another. Point to be noted, students, over here change of register is there, but only from one state to another. If company has shifted within the local limits or from one ROC to another ROC within the state, this will not affect the company from filing application STK2. But when it is shifting its registered office from one state to another, then in that case it cannot apply for STK2. Okay. After that, if company has done disposal of its valuable asset and because of that disposal or sale of the asset, they have got a profit out of that. So this disposal or sale was in the normal course of its business. Okay, and they have gained a profit on that. In that case, when company has disposed any of its important asset previous 3 months, it cannot apply for STK2. Okay. Apart from that, if it is doing any other activity except which is allowed under articles and memoranda, so it is carrying on any other activity, it is fulfilling any other sections apart from section 248 to 252, in that case it cannot apply for STK2 because company is not in process of winding up. So when company is not in process of winding up, why will company file STK2? Very simple logic. Understood? After that, if it has made any application to NCLT regarding any compromise or arrangement, so first that prosecutions have to be completed with the NCLT, and later on if company fails the compromise or arrangement, company was not able to clear the compromise or arrangement, in that case only company can file STK2. So till the time proceedings are with NCLT, it cannot file application with the ROC for striking off. Okay. Yes, so please remember compromise or arrangement. After that, if company has filed application with NCLT and it wants to wind up itself as per chapter 20, this is what we are going to learn in chapter number 21. Either it is voluntary application or it is by the tribunal. In that case, company cannot file STK2. Okay, so these are the scenarios where company cannot file STK2, that is voluntary striking off. Let us revise that. In previous 3 months, it has changed its name or shifted its registered office from one state to another or disposed any of the assets of the company in previous 3 months, or it is engaging in compliance of any other section except of 248 to 252, or it has filed a scheme of compromise or arrangement with the NCLT, or it has filed application for voluntary winding up, or there is a mandatory winding up by tribunal in the NCLT going on. In that case, company cannot file STK2 and voluntary strike off the name. That's all, students. I hope you remember voluntary striking of procedure. In that procedure, what we had seen? We had seen that how company applies an STK2 and request ROC to strike off the name. In that STK2, various documents were required like affidavits, indemnity bonds, statement of accounts. Along with that, we required one document called as a NOC, that is no objection certificate from various regulatories. So what is that no objection certificate and which authorities are required to issue that? We are going to learn that. This question was asked 2 times in your exams. So please remember this. Okay. Now, as I told you earlier, NOC is to be taken from appropriate regulatory authority. All companies will not have one regulatory. Like Nidhi company is governed by our MCA, ROC only. If company is an NBFC, it is regulated by your RBI. If company is doing insurance business, it is regulated by IRDA. So this is how different types of companies are governed by different authorities. Okay. So along with STK2, we have to file various NOC in case it is applicable. In case it is not applicable, we need not file that. So first, companies which is conducting NBFC business or doing any of the activities related to NBFC, they need to take NOC from the RBI. So it will be compulsory for them to take NOC from RBI and attach in STK2. After that, if company is a housing finance company, HFCs are governed by NHB, that is National Housing Bank, right? So they need approval from the NHB. So NOC is to be taken from NHB. Apart from that, we have insurance companies. Insurance companies are regulated by your IRDA under Insurance Act. So please remember, for insurance company, we have IRDA. Okay. Apart from that, when any of the company is doing any business relating to the capital market intermediaries, the regulator is SEBI, Securities Exchange Board of India, and they need to take NOC from the SEBI. If any of the companies engaged in CIS, Collective Investment Scheme, in that case they need to take approval from the SEBI. In case your company is a asset management company, then also your regulator is SEBI. So please remember, this NOC is not applicable to all kinds of company, but when company is doing specific business and that is regulated by any of the regulatory, it would be compulsory to take NOC for STK2. Now, if any company do not comply with section 248 subsection 1, what is a penalty? The penalty is rupees 1 lakh. Along with 1 lakh rupees, ROC may withdraw or may reject your application for striking off. So please remember this. Okay. Now, What happens when company is striked off? Once company is dissolved under section 248, the name will be removed from register of company. So company is no longer operative. So it ceases to operate. Please remember what will happen? It ceases to operate. Okay, when it ceases to operate, the COI will be cancelled. ROC will not come to your registered office and cancel, but it will be deemed to be cancelled. Okay, so your COI shall be deemed to be cancelled. But this cancellation is only for the business of the company. Whenever all the liabilities are they are pending, for the liabilities, the company will be as of company's operation. Okay, so except for purpose of realizing amount of debt and payment of discharge of liability or obligations of the company will be alive, and for all other purposes the company is shut down. I hope this is clear. Now this is also very important. They may frame a case law on this and ask you, what is this? This is about fraudulent application for removal of name. Say for example, the company has huge debt or company has entered into any contract. Okay. Now company just want to run away from its obligation. It does not want to complete his obligation under the contract. So company applies for winding up, that is striking off. Okay, so what is company doing over here? It is acting fraudulently. This fraudulent behavior can be towards a creditor, stakeholder or any of the parties. Okay, so in order to run away from any obligation, if company is doing fraud, in that case, company's directors and officers who are liable for that shall be responsible personally. Okay, so let's see the provision. If it is found that company has made application under this with object of evading any of the liabilities or any of the contractual capacities. So what company is doing? Evading any of the liabilities or intention to defraud the creditors or any other person. Three things to remember. First, company has filed application for evading liability. Second, with intention to defraud creditor. Third, or to defraud any other person. So, even any other person is included, please remember. Okay, then the person who is in charge of the management shall be responsible. Even if ROC has striked off the name, then also it does not matter. So even though your company is striked off, but the person who are into the management, like the directors of the company, shall be jointly and severally responsible for the losses who have actually occurred. Okay, loss or damage as a result of being dissolved. Very clear with this? Understood? So when, because of the dissolution of the company, any of the person has faced the losses, say for example, loss was 50,000, directors, all the directors will be jointly and severally liable to pay that 50,000 to that person. First point. Second, they can also be responsible under section 447, that is a fraud. So please remember. Okay, what are the things to be remembered over here? First of all, when company is filing application under 248 for evading any of the liability, defrauding the creditors or defrauding any person, all the directors shall be jointly and severally liable to pay off the loss or damage which has resulted to that person because of winding up. Also, they will be responsible under section 447. Is it clear? Great. Okay, now who will be authority to punish them? Your ROC. Okay, ROC shall be authority to punish them. I hope this is very clear. Now, what are the liabilities of directors, managers, officers and members? Even if company is striked off, even if name of the company is removed from register of members, still the liability of director, manager, officer shall remain active as if company has not been dissolved. That's why in STK2 we file a undertaking Directors have to give undertaking that company's assets are enough to pay off the liability. So their liability shall continue. I hope you have understood all these sections. This is a very nice form list given. You can remember the form list like this. Okay. So now we are going to see about the restoration of name of the company. Just understand this. Whenever any of the company, okay, is striked off. Striked off means what? Whatever register your ROC was maintaining, okay, from this register your name is struck off. Your name is struck off means this company now ceases to operate. Okay, so it is no more operative, and we have seen two types of strike off. Okay, two types of strike off we have seen. The first strike off we saw was suo motu by ROC. Okay, so when company failed to do certain things, like failed to file INC 20A, failed to take the subscription money, do not start business within 1 year. Okay, so when all these things are done, ROC may suo motu strike off the name of the company by giving the notice. The procedure we have already learnt. And the second type of strike off was company voluntarily wants to strike off. So this is voluntary striking off by the company. So now, as far as restoration is concerned, guys, over here ROC has suo motu striked off the name. So when the company was operative, when your company was operative, it is very active. Operative means it was very active. It was carrying on business. Just because you have not filed the annual written financial statements for last 2 years, okay, for that reason company has striked off. For that reason ROC has striked off your name, but your company is active. Okay, so when ROC has striked off the name and directors of the company are not happy with the decision of the ROC, they can apply for the restoration of name of the company to the NCLT. I'll repeat, whenever ROC has striked off the name of company and directors of the company are not happy with the decision of ROC, they can appeal against the decision to the NCLT. Can ROC restore the name? The answer is no. ROC can only strike off the name. The restoration authority is given only and only to the NCLT. Okay, so when company was active, operative, directors or other stakeholders, okay, directors or other stakeholders can apply for restoration of name of the company. With whom? With which authority? Only and only NCLT. Understood this one? Now the second striking off was by the company. So company has applied to ROC in STK2. Apparently everything is fine. But after ROC has given the striking off order, that means ROC has given STK7 to the company. So now company is no more there. But later on ROC found out that the name of the company was striked off inadvertently by giving wrong documents. In that case, ROC may apply for restoration of the name. So whenever ROC wants to restore the name, at that point of time also ROC has to go to NCLT. Understood? So in the second case, when ROC thinks that name was striked off inadvertently or by filing false documents, okay, in that case ROC may apply for restoration apply for restoration to whom? None other than NCLT. I hope this part is very clear. So when ROC suo motu striking of name of company, if directors are aggrieved party, directors of other shareholders can file application to the NCLT for restoration. But if this striking off is done by the company making application, and if ROC is not satisfied with that later on, and if it thinks that the name was striked off inadvertently, in that case it may apply for the striking off. I hope this is very clear. But remember one thing, your application for restoration, okay, your application for restoration has to be given within 3 years of striking off. It is to be given when? Within 3 years of striking off. After 3 years, NCLT may or may not take it into consideration. So if directors want to file within 3 years, if ROC wants to file within 3 years. I hope this is very clear. Okay? Yeah. Now, so on what grounds restoration might be possible? So let's see the grounds for restoration. So the grounds on which restoration is possible. Okay. So restoration is possible first of all when the name of company was removed inadvertently. This ground is valid for both the cases, either ROC applying or either company applying. Okay, so first, name of the company was removed inadvertently. So even directors can claim this. Okay. Second one, company or ROC. Okay. Company or directors gave incorrect information. Company or directors gave incorrect information. This case is there in case of voluntary striking off. So ROC can claim this. Okay. So these are the two cases where ROC may claim for restoration of name or company may claim for restoration of name if they are not happy with the decision of ROC or the company respectively. Okay. Now, the next one is who can apply for this restoration of name? Who can apply for restoration of name? Okay, who all can reply? Who all can apply? The first one is company. Okay, company can apply. Second, even workmen can apply. Whoever are working in the company, workmen can also apply. Third, the directors of the company can apply, no problem. Fourth, ROC may apply. And fifth one, your creditors may also apply. Okay, so company, workmen, directors, ROC and creditors, they all can apply for the restoration of the name. But what are the conditions to be fulfilled? In this, condition has to be fulfilled. First of all, the company was operative. When company's name was striked off by ROC inadvertently, the company was in full swing operation. Okay, so the first one, company was operational. It was going on. Okay, second one, ROC had inadvertently removed the name of the company for register and NCLT thinks that it is just an equitable to revive the company or to restore the name of the company. So NCLT thinks that it is just an equitable to restore the name of the company. Okay, who thinks this? This is done by your NCLT. So your NCLT thinks that it is just unequitable to start the company or restore the name of the company. Okay, so when application is made by company, workman or any of the director, ROC creditor, NCLT thinks that the company was operational or it is just unequitable to restore the name of the company. In that case, NCLT may restore the name. Okay, the name of the company only till 20 years from the date of publication of the official gazette. So suppose on 1st of Jan 2022 in official gazette ROC had filed STK 7, that is final notice of strike off. So within 20 years of that, company's name can be restored. Now you'll say, ma'am, earlier we read 3 years. I understand 3 years, but a buffer period is given, and that's why if NCLT thinks after cessation of 3 years but within 20 years, NCLT finds it is just unequitable to restore the name of the company, it may restore. Okay, but only till 20 years from date of publication in official gazette. Only till 20 years, not more than that. Is it clear? Understood everyone? Who can apply? In what cases NCLT may restore and within how many years? Okay, now we are going to see procedure for the restoration. Procedure for restoration of the company. What is a procedure to restore the company? The very first step, we have to apply to NCLT. Okay, we have to apply to NCLT in form NCLT 9. So what is the first step? Apply to NCLT in form, please remember, NCLT 9, plus we have to submit demand draft of rupees 1000 rupees. This NCLT 9 is a petition. Okay, and this petition has to be filed in 3 copies. Okay, so NCLT 9 is a petition to be filed in 3 copies. Along with that, we need to submit a demand draft fees of 1000 rupees. Is it clear? Apart from that, once NCLT receives a application, it evaluates the same, whether there is the case of restoration or not. On the basis of evaluation, NCLT may accept our application or it may reject our application. So NCLT may accept or reject. Once it rejects, so your petition stands cancelled. Your petition stands cancelled. NCLT don't want to revive your name, so it is not thinking that there is any case on this, so it will just reject it. But when NCLT has accepted, third point, in case ROC has striked off the name, okay, ROC has striked off the name, in that case NCLT shall give notice to ROC. Okay, at least 14 days. Okay, so it will give notice to the ROC saying that company has applied for restoration of the name. If you have any problem, please give your objections within 14 days. So within 14 days they have to give the objections. But if the application is made by ROC only, in that case no need to give application to the ROC. But rather when ROC has applied for restoration of name, NCLT shall give notice to the company saying that if you have any objections, please write us within 14 days. We are going to restore your company. If you don't want to restore, please write to us. Okay, so it will be waiting for the objections. If objections are received, there will be hearing. On the basis of the hearing, the approval or rejection shall be given. Okay, after that, after hearing the parties, it shall grant the final order. Final order may be rejecting the application for restoration. That means no revival of company, right? But in case it is approving, it shall restoring the name of the company. So what it shall do? It shall give the restoration order. So once NCLT gives restoration order, it will be duty of ROC to bring back name of the company on the register of companies. I hope this is very clear. Okay, so this order shall be given by your NCLT. This order company shall file with the ROC. Okay, company shall file order of NCLT with ROC within 30 days of order. How many days? Within 30 days. Okay, and this shall be filed in INC 28. So once ROC get this order, in that case ROC shall restore the name of the company. So I hope you have understood the process for restoration of the name. Now we are going to start with striking off of name of LLP. Just like companies, even LLPs can be struck off. Okay, so what are the grounds on which LLP can be struck off? Can LLP apply for voluntary application like company or not? What is the procedure for both of striking off? All this we are going to learn over here. Okay, as we know that for company and LLP, we have only one regulator, that is your ROC. Okay, so certain sections of Companies Act are also made applicable to LLP with the permission of the central government. So in what scenario ROC may suo motu file strike off of LLP? Like ROC can do suo motu striking off of company, ROC can also do suo motu striking off of LLP. Only 2 cases are there for LLP, whereas for company we had 4 cases. So what is the very first case? The very first case is where LLP is not doing any business since 2 consecutive years. Okay, LLP is not carrying on any business since 2 consecutive years. Since 2 consecutive years. So when any of the LLP is not doing business for 2 consecutive years, ROC comes to know about it, ROC may suo motu proceed for striking up of LLP. Can ROC strike off LLP without giving any notice? The answer is no, it has to follow the procedure. Now the second scenario is, if LLP failed to commence any business within 1 year of incorporation, then also ROC may proceed for suo motu striking off. So what is the second scenario? LLP failed to commence business. Okay, LLP failed to commence business within 1 year of incorporation. So when LLP failed to commence a business within 1 year of incorporation, ROC may start the suo motu striking off of LLP. I hope this is very clear. Okay. So these are the two scenarios where ROC may strike off any LLP suo motu. So let's see what is a procedure. What is a procedure for suo motu striking off of LLP by your ROC. So who is striking off over here? ROC is striking off. So can ROC strike off like that only? The answer is no. It has to follow a procedure. So what is a procedure? Let's see that. Same like the company. First of all, ROC has to issue a notice to the LLP that we are going for striking off your LLP. If you have any problem, do write us within 30 days. Understood? The same like your company? Yes. So what is the first step? ROC shall serve the notice to LLP. This notice, okay, this notice is given at the registered office of LLP and also at the registered address of all the directors. Okay, registered address of all the directors. So this can be sent via registered post. Okay. One more option it has. Notice may be served via email as well. On the email ID of the company and email ID of all the directors. You may also call it as a designated partners. Yeah, instead of directors, we also call it as designated partners. So in all the address of the designated partners or all the email IDs of the designated partner. I hope this is clear. Yes. After that, LLP have to give representations to ROC within 30 days, same like company. Yes. So LLP shall give written representation. Okay, what kind of representation? Written representation to ROC. Within how many days it has to give? Within 30 days. Okay, so within 30 days of receipt of notice, LLP has to give a written representation. If LLP fails to do so, ROC shall continue or proceed with the striking off. Okay, after that, once representation is given by the LLP, okay, two circumstances may happen. If it is satisfied with the representation, it shall not strike off the LLP. If it is not satisfied with the representation or when there is default in filing representation, it may proceed to the striking off of the LLP. So first scenario, it is satisfied with the representation, shall not proceed with the strike off, and when it is not satisfied with the representation or when there is a default in filing the representation by LLP, in that case it shall proceed for strike off. Is it clear? Understood all 3 points? Now going to the fourth point. When it proceeds for striking off, as we know, it shall publish in the official gazette, website of MCA and also in the two newspapers that it is going to strike off the LLP. Okay, so ROC shall publish the name of LLP to be struck off. Okay, where it shall publish? 3 places. 1, official gazette. second, website of MCA, and third one, 2 newspapers, right? One vernacular and one English. In this, what it shall serve, that we are about to strike off this LLP. If anybody has any objections, do come to us within 30 days. Okay? So what it tells, raise objections, if any, only within 30 days, over here 1 month. Remember, for company it is 30 days, over here for 1 month. Okay, this was your fourth step. Then ROC will not send it to any other regulatory, because regulatory for LLP is only ROC, nobody else. Understood? So ROC shall wait for the objections. Okay, if objections received, okay, if objections are received, it shall call for hearing of two parties. Okay, if objections are not received, it shall proceed for strike off. Don't you think this is very easy now, because you have read it once? Also, you don't have to remember any form numbers for LLP. Okay, so this becomes very, very easy. After that, this will be last intimation given by ROC to LLP that we are about to strike off. If you want to pay off all your liabilities, remove the cash from the bank, close the bank account, please do the needful. So ROC shall give notice to LLP, okay, to realize the assets and liabilities. Also, it shall take undertaking from its designated partners. Okay, very important. ROC shall take undertaking from whom? The designated partners, that assets of the LLP are enough to pay off all its liabilities. What is the undertaking? Assets of LLP are enough to pay off all the liabilities. Okay, this is very important. This we took in the company also. Yes, it shall also be taken as far as LLP is concerned. So after this final notice is given in point number 7, ROC shall publish the final notice of striking off of LLP in official gazette. From this day, your LLP stands dissolved just like a company. Okay, so ROC shall give final notice of strike off. Where? In the official gazette. Okay, after this day, LLP stands dissolved. Very clear with this? Understood? How to strike off LLP by ROC? I hope this is very, very clear to all of you. Right? Yes. Only 7 steps are there. Now let's see what is given in our notes. First of all, we are going to see suo motu application by ROC. So your provisions of section 75 read with rule 37 of LLP amendment rules, LLP can be striked off by the ROC also. In what circumstances? Only 2. LLP not carrying on business for 2 or more consecutive years, or LLP was not carrying on any business since incorporation. In that case, ROC may suo motu strike off. What is the first step? ROC shall serve the notice. Second, LLP has to give the representation within 1 month. Third, representation shall be considered. If ROC is satisfied, no strike off. If not satisfied, strike off. Then publication of notice within this 1 month, if anybody has objections, they can come. This publication happens in 3 ways: official gazette, 2 newspapers and website of the MCA. After that, after 1 month, ROC may proceed for the striking of final call to the company for realizing any amount due, any obligation give. Also, undertaking shall be taken from the designated partners that assets of LLP are enough to pay off all its liabilities. And finally, the final notice of dissolution shall be served in the official gazette. So on, from this day your LLP stands dissolved. I hope this was very clear to all of you. This was striking off of your LLP by ROC suo motu. Now let's start with the next procedure, that is LLP filing voluntary application with the ROC. Okay. Now LLP, whenever it wants to strike off itself, in that case, same like company can apply for voluntary striking off in form number LLP24. Which form is there? LLP24. For company it was STK2. Right? So same like company, even LLP has to follow certain procedure. First of all, we'll understand what is the criteria. When LLP wants to file LLP 24, it has to first stop its business for at least 1 year. So when LLP is not carrying on any business for the period of 1 year, then only such LLP can apply for striking off. Is it clear? So 1 year becomes very important. If you are doing business and you have stopped business from 6 months, can you apply for the LLP 24? The answer is no. You have to wait till 1 year. So at least 1 year should have elapsed and you have stopped doing business, we can apply for the LLP 24. Is it clear? Yes. So before applying for LLP 24, we have to comply certain provisions. So first one is we have to call and hold the meeting of partners of LLP. Just because we are closing down the LLP, we will be calling all the partners of the LLP and we have to take their consent. Okay, so consent of all the partners shall be taken to make application under this provisions. Okay, so once we obtain the consent, the second thing we need to check is whether our filing is up to date or not. That means if company has filed form 8 and form 11 with the ROC or not. If any of the years filing is pending, we cannot start with LLP 24 process. So before exiting your LLP, we have to complete all your filings. I hope everybody remembers what is the penalty for that, right? So we have to complete all the filings, that is filing of form 8 and form 11. Okay, it should be up to date. After that, if our LLP is regulated by other regulatories, we have to obtain NOC from that. Okay, so NOC shall be obtained by the such LLPs regulated by the other act. Same like companies, designated partners have to execute an affidavit. This affidavit shall be executed individually by each and every designated partner that they undertake to pay off all the liabilities of the LLP and assets of LLP are enough to pay off all its liability. And they will assure that LLP is not doing business since 1 year. They will also assure that even after closure of LLP, whatever liabilities are remaining outstanding, they shall be paid off. And all the designated partners shall be jointly and severally liable for that. Okay. So, liability of partner would not extinguish even after closure of LLP using LLP 24. After all these documents are made, the application we have to file with ROC is LLP form 24. In the LLP form 24, which all documents we have to annex? We have to annex a statement of assets and liabilities. I had showed you how statement of liability should look. Okay, asset and liabilities, it should be 0. So zero asset, zero liabilities. Except of the contribution, nothing should be outstanding. Only such LLPs can apply under this provisions. Other LLPs where creditors are standing, assets are not enough, such LLPs cannot provide under this act. Okay, so statement of accounts we require where nil assets and liabilities are there. Such statement should not be older than 30 days from the application. Next, we require latest acknowledgement copy of your income tax return. So at least LLP should have completed 1 year, filed its income tax, only then we can go for the striking off of the LLP. Then we require LLP agreement. After that, affidavit which will be signed by all designated partners. Now, which all points we need to insert in LLP? Very important. They may ask you to draft an LLP. First thing, LLP has not commenced its business or it is not carrying on business since 1 year. Okay. After that, LLP has no liability and indemnifying any liability it may arise after the striking off. After that, LLP has not opened the bank account. If it had opened a bank account, the bank account has been duly closed and we require a certificate of that closure of the bank account. Then LLP has not filed any income tax return when it was carrying on any of the business. Then detailed application, you have to write full details of LLP, why you're closing down your LLP. You have to write the full details of that. Apart from that, we require a copy of authority and it will be duly signed by all the partners. So once we give this documents along with your LLP 24, ROC shall publish this notice in the official gazette, along with that the website of MCA and the 2 newspapers. And this notice shall be valid for 1 month. That means if anybody has any objections, they can come to the ROC, object within 1 month. If they don't object, then afterwards they cannot object. So after expiry of 1 month, if nobody tried to prove that LLP has to be revived, then ROC shall proceed for the striking off. But when there were objections, ROC shall also look for the hearing. After that, the provisional realization intimation shall be given. ROC shall issue a notice to LLP that we are going to close down your LLP. So if you want to realize any of your assets, pay off the liabilities, close the bank account, please do everything needful. In this stage only, ROC also take the undertaking from the designated partners. In event of closure of LLP also, in case any outstanding liabilities are there, it shall be paid off by the designated partners. Then notice of dissolution will be given in the official gazette. Okay. This notice of dissolution shall be published in the official gazette. After that, once it is published in the official gazette, it is deemed that your LLP is dissolved. So LLP stands dissolved on the date when the application is published in the official gazette. So LLP is no more operative. But as far as all the claims are concerned, LLP will be deemed to be operative and all your designated partners shall be jointly severally liable to pay off those liabilities. I hope you have understood the process. Same process like the company only the form number was different. Now we shall see provisions relating to restoration of LLP. In company, we saw the detailed procedure how to restore the company. In LLP, we are just going to see overview of that. Okay. So first question, can LLP be restored? What is restoration? In the previous video, we saw how to remove the name of the LLP, how to strike off the LLP. So striking off LLP happens in 2 ways. One, suo motu by ROC. And second, LLP voluntarily want to strike off. So when this process is done, the name of the LLP is striked off. Okay. Now, if name of the LLP was removed inadvertently or There is some aggrieved party not happy with removal of name of LLP. Can it apply for the restoration? The answer is yes. Okay. So who can apply for the restoration? Who can apply for restoration of name of your LLP? First one, LLP itself can apply. Okay. Second, its designated partners or partners can apply. Third, creditors of LLP can apply. And fourth, ROC shall apply. So only this 4 people can apply for restoration of LLP, and with whom they have to apply? Same authority is there only and only with the NCLT. So any of these parties, that is LLP, partner, ROC or creditors, they want to restore the name of the LLP which is striked off, they have to apply to NCLT within 5 years. What is the time limit? Within 5 years from the notice published in official gazette. Okay. So once final notice is published in the official gazette, within 5 years of that, any of these parties can apply for restoration of name of the LLP. And with whom they can apply? Only and only NCLT, nobody else. Is it clear? Great. Now how to apply? That procedure is not applicable to you. But grounds of restoration we shall be looking into. What are the grounds on which LLP can be restored? First, when LLP was striked off, LLP's business was operational. Okay, so the business of LLP was going on. That is the first ground. So business of LLP is operative. And the second ground, it is just an equitable to revive your LLP. These are the only 2 grounds on which NCLT may approve your restoration of name of the LLP. I hope you have understood. The procedure is not applicable to you. So that's it with the chapter, students. I hope you have enjoyed the chapter, and it's a very easy chapter. So let's start with the question answer solving. Yes, so Glory Technology LLP is not carrying on any business for a period of 2 years. It desires to strike off its name maintained by ROC. Whether LLP is allowed to do so and examine. Answer is yes, LLP is allowed to do so as per provisions of section 75 Red Bit Rule 37 of your LLP Act 2009. So LLP who is not doing business for a period of 2 years or not commence business, they can apply in LLP form 24 and they can strike off the name of the company. Simple it was. Situation under which company cannot apply for the strike off. This is a straightforward list available, only that much we have to write. ROC can strike off name of company on suo motu basis only after following certain procedure. The answer is yes. Over here we have to quote the case law of international printers also. I hope you remember that. Yes, it is compulsory to quote. Okay. Next, state powers of registrar in regard to fraudulent application for removal of name from the ROC. What can ROC do? ROC may apply for the restoration of name of the company by applying to the NCLT. Also, the directors of the company may be held jointly and severally liable for that. They may also be punishable for fraud. So, ROC has power to recommend prosecution. So which power ROC has? It can recommend the prosecution of person responsible for filing such fraud application. Understood? Can it do prosecution himself? No. It can just recommend. So please remember the word recommend. Okay. Next. List out company which cannot be removed through procedure prescribed under 248. Again, the same one. In case of application for removal of name is filed, what are attachments of STK2? I hope you remember. NOC, indemnity, affidavit, statement of income and liabilities, etc. Various grounds on which promoters of company can close down company being non-operational. Okay, 4 grounds are there. I hope you remember those 4 grounds. Not commenced business within 1 year. Not operational since last 2 years. Subscribers failed to bring in money. Not filed INC 20A. Simple. Whether your answer will change if company has changed its registered office from Delhi to Noida 2 months back. Delhi to Noida. Okay, let's see. Certain companies cannot file application if these things are done in previous 3 months. Okay, so one of them is change of registered office from one state to another. But over here, do you think company has changed its states? No. So over here, company can file application, no problem. I hope this is very clear. Okay. So we are going to the last chapter of your part C. In fact, last chapter of your entire SBC. I hope you have understood all the 20 chapters and found it very easy. Now your chapter number 21, it's not only very important from your inter level, but also it's very much important because in final level you have little advance. So whatever you are learning right now is an overview in chapter number 21. In finals you will be learning that in detail. Hence you can say you are creating a base for your finals in your inter level. So name of your chapter number 21 is Corporate Insolvency Resolution Process, Winding Up and Liquidation Process. So these 3 things we are going to learn. You might be aware of a new code which has come for addressing the insolvency bankruptcy of your individuals, companies, partnership called as Insolvency and Bankruptcy Code. Yes, we are going to learn what is Insolvency Bankruptcy Code in chapter number 21. Also, we are going to learn about a process of CIRP, how to start, what are the different regulatories under the code. Along with that, we are going to learn the liquidation, winding up of the company. Also, 2 new concepts we are going to learn, that is pre-packed CIRP. What is the pre-packed CIRP? It is also called as PPIRP. This is one kind of a corporate insolvency for the small and medium scale enterprises. So for MSME we have PPIRP. So what is that? We are going to learn in detail. Along with that, we have something called as fast track CIRP. Also we are going to learn that. So without wasting any time, let's start. So as I told you, the name of the chapter is Corporate Insolvency Resolution Process, Liquidation Winding Up. Along with that, we are also going to learn what is PPIRP. Also, we are going to learn about the fast track CIRP process. Okay, so this is what we are going to learn. So before going ahead with this chapter, I would like to introduce certain important concepts with you. Okay, so as far as weightage is concerned, it comes to around 6 to 10 marks. Okay, it is for 6 to 10 marks. So we can find questions in your exams. As of in part C, only 3 chapters are there. So we have to do all those 3 perfectly. So let's begin. In this particular chapter, right now for your SBC syllabus, we are only going to learn about corporate and LLP's insolvency. Even though CIRP covers your individuals and the partnership as well, but still we are only going to cover corporate and LLPs for your SBC part. So, whenever your corporate or LLPs, when their assets are less and when the liabilities become more, Okay, liabilities are more than the asset. This scenario, what is the meaning of this scenario? This means that your company is not able to pay off the debts, hence it is called as an insolvent company. What do we call as insolvent company? But insolvency does not become legal till the time you go to the court of law and file application for that. So whenever corporates or LLP are not able to pay off debts, every day creditors are telling please give us money. In that case, now corporates and LLPs, if they give up, they move to the court of law, okay, and over there they file a petition. Why? To declare them as an insolvent. So, when any corporate or LLP are declared insolvent by the court of law, we call it as a adjudged insolvent, or we call it as a bankrupt. So, what is a bankruptcy? It's a legal order given by the court of law and terminating this corporate's LLP as insolvent. So whenever a legal order is given by the court of law, then we call the companies or corporates as bankrupt. Clear with this? So when we will see what is the difference between the insolvency and bankruptcy, this is going to help you. Okay, insolvency means what? Till now company has not filed any application with court of law. And what is a bankruptcy? Bankruptcy means company is insolvent, and in order to declare it as insolvent legally, what is company doing? Filing a petition for the bankruptcy. Clear with this? And when court gives order, that will be called as a bankrupt. Okay. Now, going ahead. Now, when we talk about the court of law for corporates and LLP, we have NCLT, right? So, NCLT shall do all this regulations. Because for corporates and LLP, we can file application for matters relating to the company as an LLP only with the NCLT and not with anybody else. I hope this is very, very clear. So, when NCLT declares it insolvent, we call it as adjudged insolvent or a bankrupt. Clear? Understood? Great. Now, going ahead, we are going to learn the IBC code. IBC is Insolvency Bankruptcy Code. Now, why this code has come up? Reasons we will see. But the main advantage of this Insolvency Bankruptcy Code is it allows one chance, or it gives one chance for companies or LLPs to revive. Okay, so what does IBC give? One chance of revival. It gives one chance of revival. And how do they get this one chance of revival? Through a process called as CIRP, Corporate Insolvency Resolution Process. So your government don't want companies LLP to shut down just because they don't have funds. But if their market product, if their product or if their machineries or the business is very, very scalable business, then government want that company to be revived. Understood? So before winding it up, at least one chance to be given for revival, and revival chances given through which process? CIRP. Clear with this? And which code gives this chance? IBC gives. Okay. So this process, the full form is, let's write the full form of this. It's a corporate insolvency resolution process. Okay, what is CIRP? Corporate Insolvency Resolution Process. I hope this is very clear to all of you. Now, once this CIRP is begin, okay, CIRP may be successful and it may fail. CIRP may be successful or it may fail. If it is successful, means your company is revived. So no longer requirement to wind it up. Understood? So your company will be a active company. But if your CIRP fails, CIRP failure leads to liquidation of company. Okay. Once company is liquidated, then we can dissolve the company. Once company is liquidated, we can start with the dissolution. Is it clear, everybody? Understood what are we going to learn? So one chance of revival is given, that is through CIRP. CIRP is successful, then active company, no longer liquidation. If not successful, liquidation and dissolution. We will come to what is liquidation, what is dissolution, don't worry. This much is clear. Okay, great. So now let's see some history. Before that, I would like to introduce the code. The full name of code is Insolvency and Bankruptcy Code 2016. What is the name of this chapter? Insolvency Bankruptcy Code 2016. Are we going to learn entire law here? This law has 255 sections. No, we are not learning entire law, but we are only learning an overview. Okay. So, what is this IBC and what all are covered? Under IBC, listen guys, only companies are covered. LLPs are covered. Partnerships are covered and individuals are covered. Okay, so who all are covered? Companies, LLPs, partnerships and individuals. Any of them getting insolvent, we can go to IBC, follow the IBC. Okay, why we will follow IBC? Because any one of them is not able to pay off its liability, then we will go to IBC. Now, if trust becomes insolvent, can we go to IBC? No. If your society becomes insolvent, any of the other incorporated body becomes insolvent, this all are not covered under IBC. These all are not covered under IBC. So who all are covered? Companies, LLPs, partnerships and individuals. Simple. Great. Now, let's see what was the scenario before IBC came. Before IBC came, what was the scenario? If individuals became bankrupt, okay, their applicable law was Presidency Towns Insolvency Act 1909. Okay. Also we had an act called as Provincial Insolvency Act 1920. Okay. So when individuals were insolvent or bankrupt, we used to follow this law. And when companies went bankrupt, when IBC was not there, the companies were regulated under SIRC, Industrial Companies Act. Okay, it was 6 Industrial Companies Act. Clear with this? Understood? But now, once IBC came, all these laws will not be applicable to individuals and companies. Basically, they are abolished. This all are abolished or repealed. Simple. Understood? Now, After IBC, there are many changes in the various laws. Which laws are abolished? I have showed you these laws are abolished. Okay. So after IBC, many amendments have come in various acts or various enactments. Many amendment in various enactments. Okay. So which all enactments we are looking which are altered because of this act? We have our Companies Act 2013. Okay. So Companies Act 2013 major changes have come. Why? Because earlier Companies Act was dealing in winding up of company. Now winding up of company is not done as per Companies Act, but it is done as per the IBC. Also, there are a lot of changes in the LLP Act because now winding up liquidation of LLP happens as per the IBC. Along with that, many changes in the Partnership Act because of applicability of IBC. Many changes in the Central Excise Act. Many changes in the SURFACE Act. What are the changes we are not going to see? Many changes in the Recovery of Debt Act. These are the few gist I have given. Lot of changes are there in different laws. So you can just to make a note of it that before IBC what was the scenario and after IBC many changes are there. Before IBC these laws were there. The upper laws are now abolished, no longer applicable. The below after IBC laws are applicable with amendment. Simple with this, understood? Great. Now we will see why IBC. What was the need of IBC? Why can't we follow the earlier laws? Why there was a need of an IBC? IBC has come up for fast winding up, fast liquidation. You know the main reason why foreigners don't like to invest in India, it is because of the huge process to shut down the companies. Their money gets stuck for years and years because our already courts are burdened with so many cases. So there was no process for winding up company which was time bound. But for the first time, CIRP has given a process which is a time-bound process for closing down the companies. I hope this is very clear. Understood? So this is a main reason why IBC has come. Okay, so first reason, everything came under one roof. Everything came under one roof. Now what is everything came under one roof? First, if partnership wanted to be winded up, we used to go and check Partnership Act. LLP, we used to check LLP Act. Companies, we used to check Companies Act. So for different winding up, different insolvency, we had to refer different acts. But IBC has compiled all entities, that is individuals, partnership, LLP and companies, winding up, liquidation, dissolution and insolvency procedure under one code, that is a IBC. Simple, understood? That's why it is called as under one roof. After that, it also helps to reduce the burden on courts. Also, it reduces time for closure of entities. That's why I told you IBC has a process of CIRP which is a time bound process. You have to complete within the time, otherwise what will happen? You will be liable for the penalty. Okay. After that, it is very cost effective also. We have different types of CIRP process, fast track, lengthy procedure. Also we have process for MSME which will help MSME to come out of their insolvency. Understood? Or whatever effect has happened because of the COVID on them. Okay? Yes. So these are the various reasons why IBC has come. So I hope you have understood what are we going to learn in this act and how are we going to learn. So this was all about the introduction, guys. So now let's start with the next provisions, that is various authorities under IBC, and we are also going to see the definition. So first we will see what are the different authorities under IBC. Under IBC, we have a insolvency board called as IBPI. Okay. So the name of the board is Insolvency and Bankruptcy Board of India. Okay. This is called as IBPI. In our further notes, please remember this short note. Okay, this is how we are going to spell. So what is IBPI? It's Insolvency and Bankruptcy Board of India. This is the authority which will be regulating your insolvency and the bankruptcy procedure. Along with that, it will also appoint various professionals for carrying out this insolvency and bankruptcy procedure. So your IBPI, it has two entities under him. The first one, Insolvency Professional Agency. What is the name of this? It's an Insolvency Professional Agency. So in this Insolvency Professional Agency, you have your professionals who will be doing your insolvency, CIRP process, liquidation process, winding up process. Okay. So this insolvency professional will be carrying out CIRP process, and also they will carry out the liquidation process. So even though it is insolvency professional agency, the person who will be carrying out this CIRP and liquidation will be called as a insolvency professionals. What will be they called as? Insolvency professional. Now the other entity which is formed under IBPI is Information Utility Agency. Information Utility Agency. Now what is this Information Utility Agency? See, whenever any company's liquidation, bankruptcy process is going on, they need to take out the track record of the company, that how they were dealing with the loans and deposits which they have accepted. So they need to check the company's books of accounts every time they need to do the inspection of books of the company. So instead of doing that, this agency, that is Information Utility Agency, will be keeping all the track record of which company has taken which loan and have the loan been paid or not paid. Understood? So basically I can say they will be taking care of the credit information of individuals, companies, LLPs and other entities. So this will be the role of Information Utility Agency. So what they will do? There will be a Information Utility Center. Okay. And in this center, they will keep record of all defaults done by the company. So when any person wants any record of company, instead of going to the company, they can go to the Information Utility Center, and Information Utility Center can provide them with the details. I hope this is very clear. So under IBPI, we have two entities: Insolvency Professional Agency, where the insolvency professionals shall be carrying out CIRP and liquidation. Then we have Information Utility Agency, where the credit information of company, defaults of the company will be kept. I hope this is clear. Now going ahead with the adjudicating authorities under this act. Adjudicating authorities. Okay. What about the adjudicating authorities? Now listen to this very carefully. This adjudicating authorities I divided into two. One adjudicating authority will be there for individuals and partnership, because these are the different entities, and the other one we have for company and LLP. So company and LLP adjudicating authority is one. So who is the adjudicating authority for individuals and partnership under IPC? It is called as Recovery Debt Tribunal. What do we call it? Recovery Debt Tribunal. Okay. So whenever any individual or partnership gets bankrupt or insolvent, which court they have to go to? Can they go to NCLT? No, but they have to go to Recovery Debt Tribunal. And if they want to file appeal, if they are not happy with the Recovery Debt Tribunal, then they can go to Recovery Debt Appellate Tribunal. So we have RDAT, Recovery Debt Appellate Tribunal. As far as company is concerned, companies have to go to NCLT. So companies and LLP will be going to the NCLT under the IBC also. And as far as appeal is concerned, if they are not happy with the decision of NCLT, we have appellate authority in NCLT called as National Company Law Appellate Tribunal. So they will be going to NCLAT. Simple. So these are the adjudicating authorities. For individual and partnership, Recovery Debt Tribunal. For companies and LLP, NCLT. In case they are not happy with the decision, then RDAT and NCLAT. Okay, so this was very, very important. Now, if, listen to this carefully, if they are not happy with the decision of RDAT and NCLAT, be it individual, partnership, company or LLP, they can go and file a case with Supreme Court of India. So if individuals, partnership, LLP or company are not satisfied with the decision of the appellate tribunal, they can file appeal with the Supreme Court. So this is your adjudicating authority under the IBC. Please remember this. Okay. So we have seen various authorities under IBC. Please remember IBBI we saw. Under that we have insolvency, professionals agency and information utility and various adjudicating authorities. Please remember. Now as I told you that IBC is going to give a chance of revival. So how IBC gives chance of revival? Along with that, there is something called as that there is time bound process to do all this, like CIRP, winding up, liquidation. So how are we going to go ahead? So before learning them, we have to read the definitions. We have to learn the definitions. So first definition we have is a financial creditor. Who is a financial creditor? Who gives loan to the company? Okay, and he is giving us not the working capital loan, please remember. He is giving us various other kinds of a loan like your FIIs, banks, all this can be your financial creditor, not giving the working capital loans. Okay, so who is a financial creditor? Who gives loan to the company. Okay. Second kind of creditor we have is a operational creditor. Such kind of creditor gives you working capital loans. Which kind of loans they give you? They give you working capital loans. Like purchasing raw materials, you purchasing machineries. These all are the working capital loans. Okay. And the third one, we have a corporate debtor. Corporate debtor is nothing but your company and LLP itself. Okay, so financial creditor is who gives loans to the company other than working capital. Operational creditor gives you working capital loans, and corporate debtor is your company or LLP itself who is in line of getting insolvent. Okay, so who can file this CIRP? CIRP can be filed, that is, there is a process of corporate insolvency resolution process. Who can start that? For starting CIRP, we need to apply to the NCLT. What we need to do? We need to apply to the NCLT. Okay, we are talking about the CIRP. Who can apply to the NCLT for starting CIRP? Your financial creditor, your operational creditor, or the corporate debtor himself. Even corporate debtor himself can also start with the CIRP. So, on behalf of company LLP, who may file this application? It can be your manager, it can be your MD, it can be your whole-time director, any person who is having powers. In case of company, who can file? It can be partners or it can be designated partners. So they can apply to the NCLT for starting the process of CIRP. Please remember, who can file? Financial creditor, operational creditor, or corporate debtor. They only can start the CIRP. None other than this can start with the CIRP. Is it clear, guys? Great. Now going ahead, the fourth one. The fourth one we have is what is a financial debt? What are we going to learn? We are going to learn what is a financial debt. Okay, this is a fifth definition. We'll be learning it like this. Okay, because you need to understand what is financial debt. If you have a financial debt, then only you have a financial creditor. Understood? So financial debt is given by that financial creditor. So what all things are there? First of all, money borrowed by the company is a financial debt. Okay, so money borrowed by the company becomes financial debt. Second one, if company has taken any credit facility, even that becomes financial debt. If company has taken any credit facility, it also becomes a financial debt. If company has issued any debentures, bonds, or other debt instrument. Okay, if company has issued debenture, bonds, or the debt instrument, even then it becomes a financial debt. If company has taken something on lease or hire purchase, it can be land, it can be any asset of the company also. So company has taken any asset or any land on lease or hire purchase, even that is a financial debt. Then the next one, it's a counter indemnity guarantee. Counter indemnity guarantee. Now what is this? When company has taken loan from XYZ and Mr. Y is a guarantor for you, you defaulted. Okay, so now Y paid on behalf of you. So now Y has entered into shoes of your creditor. So it is a counter guarantee. You have to pay that amount to whom? Your counter creditor, that is your Y. Very clear with this? That is called as a counter guarantee. After that, next one we have any purchase of flat. See, when any of the company is under construction, okay, and builder gives you an undertaking, I am going to give you possession within 2 years and there is an agreement done. Buyer has paid the entire payment for that. Buyer has given entire payment, agreement is done. But your company, that is your builder, okay, you are doing a construction work. So company failed to give possession after 2 years. So when company fails to give possession on the predetermined period and buyer has paid the full amount, so your buyer of the flat becomes your financial creditor. Understood? I'll repeat. When any company is doing any of the construction work and company has promised the buyer to deliver flat or give possession of flat within 2 years. On the predetermined day, company defaulted in giving the possession, but buyer has paid the full amount. So suppose buyer has paid 1 crore rupees. Your company becomes debtor to that buyer. So now this buyer will be treated as a financial creditor and company has to pay interest on that amount. I hope this is very clear. So in case of a purchase of a flat, payment given by buyer in full, please remember this. So in that case, buyer of the flat will become the financial creditor of the company. Okay, understood? Yes, this definition is to be remembered. It's very important. Going to the next one. In case of market value of shares, okay, you contract to purchase shares at some amount. Okay, basically that is a derivative contract. Okay, so that will also be called as a financial debt because you have promised to purchase that at particular amount, so it becomes a financial debt. So all this, okay, all this is your financial debt. So any person who gives you this facility, like somebody gave you loan, credit facility, the buyer of the flat, the counter guarantor, the lessor or the lessee, the hire purchase, all this will be your financial creditor and your company is a debtor. Simple. Understood? This is the definition of a financial debt. Please remember this. It comes in exam, straightforward question for 3 to 4 marks. Now we'll go to the next definition. Sixth one. Committee of creditors. Committee of creditors is constituted by your insolvency professionals. Who constitutes? It is constituted by your IP. IPs are insolvency professionals. Okay. Please have a habit of now shortcuts. So IBBI is Insolvency Bankruptcy Board of India and insolvency professional is your IP. Now this committee is formed in the process of your CIRP. So this is basically committee of all the financial creditors. Okay, we are going to learn about this committee, don't worry. Okay, so these are the basic definitions. I have explained you the concept over here so that it becomes very easy for you to learn. Now let's go to our notes. Yes, so basic departure from old law in the new code is that company which has gone insolvent cannot start liquidation at primary stage until and unless it has gone through a process of CIRP. So basically it is given one chance for companies to get revived. Okay, so there will be option for revival and if it fails then only company can go into liquidation. This we have already seen. So we have IBBI voluntary liquidation process 2017, hence under this act only we are going to do liquidation and winding up. We are not going to do liquidation as per the Companies Act. Okay, so section 255 of Insolvency Bankruptcy Code, it is notified on 15/11/2016 and it has amended. So now in this we have CIRP, liquidation, voluntary liquidation, of corporate person and winding up. Now guys, let's see what is the difference between insolvency and bankruptcy. What is a bankruptcy and insolvency? I've already told you. Insolvency means whenever any liabilities are more, assets are less, we call it as insolvency. Okay, so it is inability of party to pay its debt in ordinary course of business. And what is a bankruptcy? Bankruptcy means it's a legal status. So whenever application is made to the court of law for declaring it as bankrupt, then we call it as a bankrupt. So debtors' assets are then evaluated and used to pay off the creditors. So insolvency basically is inability of debtors to repay their debts, and bankruptcy is a formal declaration of insolvency by law of the land. So insolvency is described where debtor is unable to meet the obligation, and bankruptcy is determined by the court of law. So first insolvency happens and then bankruptcy. So insolvency is used for individual, organization, corporate. It is used for everybody. Okay. But if insolvency is not resolved, it may further lead to liquidation of the corporates. Okay. For individuals, can you liquidate the individuals? No. But for corporates, LLPs, we have to liquidate. Okay. Yes. So now I would like to, who all are covered, we have already discussed. As I told you, there are total 255 sections and 4 parts, 5 parts we have. We are going to see part 2, corporate person. We are not going to see part 3. We are going to see part 4. Okay. Salient features before going to that. Definitions. Yes. So what is an adjudicating authority? I have already told you. For individuals different, for partnership different, LLPs and companies also different. Who is a corporate applicant? It can be any person, it can be corporate debtor or any member partner in case of a partnership or LLP. Any person who is managing the work of that particular LLP or company, or under whose control, supervision the entire financial affairs is there. So corporate person also includes your LLP. Please remember this. Okay. But it does not include any of the financial service provider. What is a corporate guarantee? Means a surety which is given is called as a corporate guarantee. Who is a financial creditor who gives loan to the company owed and includes person to whom debt has been assigned or transferred. We have already seen definition of financial debt. I hope you remember that diagram. Yes, so that becomes important to remember, very important definition. Now, who is an insolvency professional? Insolvency professional is defined under section 206, who is a member of insolvency professional agency. So insolvency professional is member of insolvency professional agency and also registered with IBBI. Okay, what is insolvency professional agency? It is any person which is registered with IBBI. Now, what is insolvency resolution process cost? Guys, this question is asked many a times. Okay, whatever cost is incurred during insolvency process, okay, CIRP process, that is called as the insolvency resolution process cost. Whenever companies' assets are sold off, realized, the first payment, the first asset is used to cover up the insolvency process cost. So what all are covered in that? Any amount of interim finance and cost which is incurred for raising finances. In CIRP, we are going to raise the finances so that somebody can buy the company with the debt. So that is raising finances. So whatever cost is incurred for that is called as a finance cost. Then any fees which is payable for resolution professional. Insolvency professional, resolution professional, one and the same. They will not do this for charity, right? So definitely fees are given to them. After that, any cost which is incurred by insolvency professional for carrying out the process, even that is covered. Any cost which is incurred at the expense of the government in order to facilitate the insolvency procedure, even that is covered, and any other cost. Okay, so all this are your CIRP costs. This will be taken first. Okay. After that, What is liquidation commencement date? All these definitions we are going to learn. We will do the liquidation part. So for CIRP we have learned the definitions. Okay. Now let's start with what is a CIRP. Okay. CIRP, Corporate Insolvency Resolution Process. So what is a CIRP? Basically, before company goings for the winding up or liquidation, one chance of revival is given to the company, okay, and that chance itself is given in the CIRP process. So they will carry out various steps and they will take efforts that company is revived instead of winding up. But yes, as I told you, if your CIRP fails, ultimately company has to do liquidation or the winding up under this act. Okay. So now in this we are going to see who can apply for the CIRP. How does it start? So what is a CIRP? It is a plan given to the company. What is CIRP? It's a plan given to the company before its liquidation. Who gives plan? The expert, our insolvency professionals. Okay. This plan is for the revival of the companies. Okay. Now the next one. It is whose authority to give chance of revival. Where are we going to file the application for CIRP? So, application for CIRP to be filed with NCLT. We have seen the adjudicating authority, so for company it is NCLT. Now, the next, who can apply for CIRP? This is very important. And how actually your CIRP start? CIRP can be started by, I have told you this when we were learning the definitions, financial creditors of the company, right? Or operational creditors of the company, or the corporate debtor himself, or the corporate debtor himself. So these three people may apply to NCLT for starting the CIRP process. Now how can they apply? Now we are going to see that procedure. So first application, suppose your financial creditors of the company wants to start with the CIRP process. Why? Because financial creditors had given loan to the company and company is doing continuous default, not repaying. So where can financial creditor go? It can go to the NCLT. Okay. So first is application by your financial creditor. So can individual financial creditor start with that? The answer is no. Individual creditor cannot make application to the NCLT, but they have to follow a procedure. So how many financial creditors are required? How many they are required? Minimum 100 creditors we required. How many? Minimum 100 or 1/10 of total creditors. Minimum 100 or 1/10 of total creditors, whichever is less. Okay. So suppose total number of creditors are 100. Out of that 10 creditors file a complaint. So 100 or 10, which one are we going to choose? 10. Understood? So 100 minimum or 1/10 of total financial creditors can go to the NCLT and file a application to start the CIRP process. Okay. Now how to start? How many we have understood now? How to start, what documents are required for starting this process. Now the document which will be required are, they have to give a record of default. they have to prove that loan was given to the company, and in respective of giving so many notices to company has not given any money to the creditor. So now creditor wants to start with the CIRP. This record of default they have to take from authority called as Information Utility Center, IUC. I hope you remember this. Okay, so they have to take this from Information Utility Center. Along with that, they need to name an insolvency professional, okay, with whom they would like to do the CIRP, because CIRP will be done by your insolvency professional only, who is member of your insolvency professional agency. So if your financial creditor is comfortable with some person who is an insolvency professional, they can start with that professional, no problem at all. Understood? So what all documents are required? Record of default and name to be given of one person, two person to start your insolvency process. So this was your procedure to be followed by financial creditor. Now we are going to the next one. The second one is your operational creditor. Okay, even operational creditor can start with the CIRP, yes. So even they have to make application to the NCLT. So how many operational creditors are required? Minimum of 100 or 1/10 of total operational creditors, whichever is less. Same concept like your financial creditor, yes, it is one and the same. Now over here process is little different, because operational creditors contributes to the working capital, day-to-day finances in the company. Okay, so what they have to do, there is a process to it. They have to follow the process. In that, step number 1. Now we will take one example before learning this. There is a company called as ABC Private Limited. ABC Private Limited purchased raw material on credit. So what did it do? Purchased raw material on credit from a company called as Shakari Private Limited. So Shakari Private Limited has sold the raw materials to the ABC on credit. So they become your operational creditors. Clear with this? Understood? So say for example, the amount which was due was 5 lakh rupees. Now on the due date, like company told I'll be paying after 30 days. So after 30 days is a due date. On the due date, company defaulted. What did company do? Company defaulted. So when company defaulted, the second step what your Shakari Private Limited or your operational creditor has to give is, they have to give a final notice to the company. Okay, they have to give final notice to the company. This final notice will be nothing but a defaulting notice, very important as far as your CIRP document. Okay, this final notice, what will it written? In that notice, they have to write that is your operational creditor has to write that you pay me money within 10 days. If you are not able to pay me money in 10 days, I am going to file a CIRP against your company in the NCLT. So this is a final notice given, company has to pay. Okay, now in the third case, third step, when company receives notice, when company receives such notice, what it has to do? It has only two options. One, pay within 10 days, pay money within 10 days, first option. Or second option, if the dispute, that is if the raw material amount is 5 lakh rupees, but your company says I have bought only 4 lakh from you, that means I have bought raw materials of 4 lakh, and the operational creditor say no, you have bought for 5 lakh. So there is a dispute going on. Okay, so it can file a dispute regarding the payment. So when there is a dispute, how is company going to pay? Understood? So what company has to do? Pay the amount within 10 days, or there is dispute regarding the payment. This too can save company from CIRP. This too can save company from CIRP. But if about two are not there, if company fails, then your operational creditor can file the CIRP. So if company fails, then operational creditor shall file the CIRP with your NCLT. Is it clear? Understood? So this was a procedure for the operational creditor. So operational creditor has to give the final notice to the company, give last 10 days time, and after that only it can file an application. But operational creditor should make sure that the amount which is pending, that should not be in dispute. If that amount itself is in dispute, NCLT will not entertain your CIRP application. NCLT will first finish off that dispute, first decide that how much you have to receive, then only come here. Clear with this? Understood? Simple? Okay, so now what are the documents we have to file? Please remember, in the fifth one, documents to be filed by operational creditors to NCLT when it is filing for the CIRP. The first one, it has to submit the invoice. Okay, it may have issued that to the company, so that invoice it has to issue. After that, operational creditor has to give an affidavit. Which affidavit? As I told you, there should be no pending dispute. There is no pending dispute. Okay, after that they have to prove that there was default of the debt. Okay, also they have to show proof of the default. How? From where it will take proof of the default? From the information utility center. Okay, so these are the documents which operational creditor has to file with the NCLT. Coming to the third one, even corporate data can start with the insolvency process. Okay, so corporate data itself can file application with the NCLT and say that I want to start with the insolvency process because I'm not able to pay off my debts. Okay, so who can file? Any member can initiate, any of the board of directors can initiate, or company can initiate. Clear with this? Understood? Okay, so these are the three ways how we can start our insolvency procedure. Okay, yes, so you can take the screenshots of this if you need it. First was application of CIRP. Okay, so now let's proceed with our CIRP process. I hope you have understood who makes the process, okay, and how application for CIRP is made, who is eligible. Only three parties: financial creditor, operational creditor, and the corporate data. Only these three people are eligible to do the application to the NCLT for the CIRP process. Now, when application for CIRP process is filed with the NCLT, what will NCLT do? Okay, we have filed application with the NCLT. Okay, so NCLT will start with the evaluation. So what is the next point? Evaluation of application. So NCLT has to complete the evaluation process within 14 days. Okay, within 14 days of receipt of application, what it has to do? It has to complete its evaluation procedure. So in 14 days, basically it has to decide whether it wants to accept the application or it wants to reject. So it shall give reply accordingly. So as per the evaluation, it shall give reply. So when NCLT feels that default is done, okay, default is done means corporate debtor is at fault, default is done. So when default is done, it may accept the application. It may accept the application for the CIRP. Okay. By looking at the application, if it feels that default is not done, whatever creditors are claiming are false, so default is not done. So when default is not done, do you think CIRP will start? The answer is no. It may reject the application. It may reject the application. Now, acceptance and rejection does not happen mere because of belief. They want proof. So, I'm writing it on the next page. I don't have space over here. So when the application is accepted, on what grounds it can be accepted, we are going to write that. First of all, it feels that means NCLT has satisfied that there is actual default happening. So looking at the documents, they can find out that actual default has happened. Corporate debtor has defaulted in payment of the creditors. Apart from that, application is complete. Application is complete. Application is complete means what? Application is complete means whatever application for CIRP is made, it is complete and none of the details are missing, none of the documents are missing. If any of the documents or details are also missing, then no rejection may happen. So when it is accepted means default has happened and application is complete. After that, no proceedings are initiated. No proceedings are initiated against the company's claims. That means, as I told you, there should be no dispute, right? So there are no dispute as to claim. So if these points are satisfied, your application may be accepted. Now we saw that application is rejected. So application rejection happens because of two reasons. One, there is a default. There is a default but incomplete application form. There is a default but there is incomplete application form. So when there is a default and there is incomplete application form, applicant shall get one chance to resubmit it. So in this case, it shall get chance of resubmission. Okay, this resubmission has to be done within 7 days. Okay, so by completing, we have to do the submission within 7 days. But when there is no default, there is no default. In that case, there is no case. Understood? So when there is no default, it may reject the application. Now, in what grounds? They have seen that there is no document which can prove the default. Okay, so in that case, can we get the chance of resubmission? No, there is no default. Or the proceedings are pending, or proceedings are initiated against company's claim. So there is a dispute as to claim. When there is a dispute as to claim, can we start the CIRP? The answer is no. So in this case, there cannot be any CIRP, and in this case, after your resubmission, if documents are found correct, then your application may be accepted. Clear with this? Everybody understood? Any doubt still here? Simple it was. Great. Now, going ahead. Once your application is accepted, once application is accepted, your CIRP commences. Okay, once application is accepted, your CIRP commences. So CIRP is deemed to be commenced on the date of acceptance of application. Why we have to see the date of CIRP? Because CIRP is a time bound procedure. So we have to complete the CIRP within number of days. So the date of application, that is acceptance of application, will be deemed to be the start of CIRP. Clear with this? Great. So assuming that our CIRP application is accepted and CIRP proceedings are started. Now we are going to the next point. So till now what we have seen? We have seen about the evaluation. Form is evaluated. After evaluation, NCLT has decided whether to accept or to reject. Okay, so now we are going to assume as it is accepted. So next point. Now, once your CIRP is started, can anybody stop the CIRP process? Yes. Who can stop? The financial creditors, your operational creditors, okay, these two people, okay, they may withdraw the application. They may withdraw the application for CIRP. How they can withdraw? In their meeting, in the financial creditors meeting, in the operational creditors meeting, they have to take the consent of 90% of creditors. Okay. How they can withdraw? Taking consent of 90% of the creditors. Clear with this? So this is how the CIRP can be withdrawn. Okay. Because CIRP is done for creditors. If creditors only don't want, then there is a new use of CIRP. Going to the next point. There is something called as moratorium. What is a moratorium? Moratorium means once your CIRP starts, all other cases which are going on in other court of law will be stopped for time being. So till the time CIRP is going on, none of the cases shall be in process. Everything will get freezed. This is called as a moratorium. So once CIRP commences, the moratorium shall be announced by the judge of NCLT, and this is how all the proceedings which are going on shall be freezed. So basically judge is saying that if you have any problem, you come to the NCLT because final decision of company is happening over here. So let's start. Moratorium. Once your CIRP commences, who declares moratorium? Please make a note of it. NCLT declares moratorium. Okay, NCLT declares the moratorium. Now, what is the meaning of moratorium? Let's write. As I told you, all the suits and all pending cases shall get freezed. Okay, all the pending suits or proceedings before any court of law, it can be any court of law, stands suspended. Do you think it is permanent suspension? No, it is only till the CIRP. Once CIRP is over, again all the cases can resume. Okay, after that, about the legal right in the asset of the company. Legal right in the asset of the company, if there is any corporate creditor, okay, if any of the person is having legal right in asset of the company, even those person has to go to the NCLT. Okay, so if any case is going on, then that case shall be suspended till CIRP. Okay, anybody wants to claim right under SURFACE. Okay, SURFACE right enforcement, even this stands suspended. If any of the creditor has come to recover the property of the company, cannot do so because CIRP is going on. So all this is called as a moratorium. Please remember this. I hope you understood what is a moratorium. Pending suit suspended, legal right in the property suspended, SURFACE right enforcement suspended, and the recovery of property suspended. Okay, now going to the next point. So NCLT has announced moratorium till now? Yes. Now NCLT shall appoint your corporate insolvency professional in order to carry out the insolvency process. So NCLT shall appoint interim resolution professional. He is the same person, only the name is different, but he is appointed by your NCLT. Okay, so interim resolution professional is an independent person. He cannot be connected to any of the creditor, cannot be connected to any of the company who is in dispute. So it is an independent authority. In case to give a fair judgment, fair process, it will be essential that your interim resolution professional is an independent person. So can he be the officer of corporate data? The answer is no, he cannot be officer of a corporate data. Is it clear? Great. After that, now once your interim resolution professional is appointed, okay, IRP, I am writing IRP for interim resolution professional. What it shall do? It shall take charge over the management of the company. Okay. So what it shall do? Shall take charge over management of the company. Okay. So this is the first thing it shall do. We will do numbering, so it would be very easy for us to remember. This is the first one. Second one, once it takes the charge, it has to do the evaluation of the claims, right? Why he is appointed? He has to see how much assets are there, how much liabilities are there, okay? And then if more claims are there, it shall also give the advertisement in the newspaper saying that CIRP started in against this company. If anybody has any claims, please come right now only. After that, claims shall not be entered. So it's just like your liquidator. How liquidator does realizing of assets and liabilities on the same way. But over here, this professional will give one chance to the company to be revived. Okay, so first step what he did, he took over the charge of the management of the company. Now board of directors shall not be handling the company's affairs. After that, it shall make a public notice. What it shall make? A public notice. It shall give a public advertise that CIRP has been initiated against this company. Okay. Claims are welcome. Whoever want to claim, claims are welcome. Claims are welcome from the creditors of the company or the public at large. Okay. So they have to give claims within 30 days of advertisement. So within 30 days of notice they should claim. Otherwise after 30 days it shall not be entertained. Clear with this? Understood? Yes. So this is the second step it shall do. The third one, it shall start doing evaluation of claims. It shall do evaluation of the existing claims, whatever claims are there. Okay. It shall also constitute a committee of creditors. It shall also constitute committee of creditors. Okay. We have seen the definition of COC, right? Committee of creditors, wherein the financial creditors of the company will be there. Okay. So their committee will be formed. This committee IRP has to make within 30 days of commencement of CIRP. COC has to be made within 30 days of commencement of CIRP. So it will be compulsory to make the committee of creditors. And who all are the members of this COC? Your financial creditors of the company. Is it very clear? Understood? Okay. So what did it do? First step, took over the management, made the public notice, evaluation of existing claim, and it constituted the committee of creditors. Now, what shall your committee of creditors do? Your committee of creditors. Please don't write the shortcuts, please write it in the full form. Your committee of creditors has to convene the meeting. Okay. What they have to do? They have to convene the meeting. In this meeting, what will be their agenda? Their agenda would be to consider the appointment of your IRP. If they are satisfied with the existing IRP, then they will not appoint new insolvency professional. If they are not satisfied, it will not be compulsory for them to continue with the old one. They can appoint the new one. Okay, so if they are satisfied, they shall continue with same IRP. If they are not satisfied, okay, they shall appoint a new insolvency professional. Clear with this? Understood? Great. Now, when we talk about the power of COC, power of COC. COC is nobody but your financial creditors, and financial creditors are the person who will be ultimately beneficiary of this IRP. So they will be the kings. Without their approval, your IRP cannot do anything. Hence, IRP shall abide on all the directions of your committee of creditors. And whenever meeting is there of committee of creditors, for passing anything, approving anything, they have to pass a resolution. And resolution is to be passed by 66% majority. How they have to pass? By 66% of the majority. Clear with this? Understood? So this is about a committee of creditors. Now moving ahead, the next point, IRP its duty will be to frame the corporate insolvency plan. Okay, it will plan in such a way that your company's assets shall be revived, so that somebody, investor shall come in who shall buy the liabilities, and this is how your company can again be revived. So it shall start framing of corporate insolvency resolution plan. What it shall start? Framing of corporate insolvency resolution plan. Okay, so this resolution plan, resolution professional shall make it. RP, IRP, all are one and the same. IP, you call it when any name. So resolution professional shall draft the plan. Okay, this plan shall be submitted to the COC, because without COC's approval, IRP cannot initiate with anything. So plan to be submitted to COC. COC shall conduct the meeting, and if it is satisfied, it may continue, and if it is not satisfied, it may make any modification as they want. So COC may approve the plan with or without modifications. With or without modifications. Now when plan is ready, plan has to be submitted to the NCLT. Okay. So plan is to be submitted to whom? NCLT. Okay. So this is making of your resolution plan. I hope it is very clear. Okay. Now listen to this very carefully. All this procedure, once CIRP commenced, IRP was there, he gave advertisement, then there was claim, evaluation of claim, there was COC, then plan was made. All this they have to complete in a time period. The time period is 180 days. Okay, so CIRP has to be completed within 180 days. It may extend by application of COC. So further application, they may get extension of further 90 days, but not more than that. So your entire CIRP, that is the main 180 days, and your extension, any other proceedings, so entire CIRP has to be completed within 330 days. It cannot exceed a single day above that. Okay, everything comes into it. So sometimes what happens is your insolvency professional fails to make any plan because the creditors are not agreeing to it. Without approval of creditors, they cannot go ahead. Okay, so let's see how the scenario happens. Now listen to this very carefully. Your corporate insolvency resolution plan is ready for submission. Okay, plan is ready for the submission. Sometimes this may also happen, no plan is ready, because maybe there is ineligibility of your professional, or the creditors are not agreeing to it, so the plan is not ready. What will happen when plan is ready? When plan is ready, it is to be submitted to the NCLT. Once plan is submitted to the NCLT, NCLT may accept the plan or it may reject the plan. Okay, NCLT may accept the plan or it may reject the plan. So when it accepts the plan, it may order to proceed for the implementation of the plan. And with this implementation, it may give certain conditions also, some modifications also. Okay, so when it accepts the plan, it may give order to proceed with the implementation of that. If it rejects the plan, then it may order for liquidation. I told you, no, if CIRP fails, what comes? Liquidation. Clear with this? Understood? Now, when any default is done in implementation, when any default is done in the implementation, or some non-compliance is there as far as order of NCLT is concerned, any interested party can make application to NCLT and NCLT may order for liquidation. I'll repeat one more time. Once your plan is accepted, you may get order for implementation. If there is any contravention during the implementation, any interested party may go to NCLT and say, please stop this implementation of CIRP because they are not following the rules. NCLT may in such case for the contravention, it may order winding up. Okay, clear with this? And second winding up when the application is rejected. Simple. Now coming back, when no plan is ready, NCLT may order for liquidation. Okay, NCLT may order for liquidation. Now very important things to be noted. CIRP is a time bound process. Okay, it has to be completed within a time, that is CIRP is to be completed within 180 days. We may ask for further extension. Okay, who can ask? Only by approval of resolution in the COC committee by 66% of majority. So if your COC thinks that it cannot complete within 120 days, then this resolution is to be submitted to the NCLT. NCLT may extend for maximum 90 days. Okay, so total number of days for CIRP cannot exceed 330. Okay, so CIRP is to be completed including everything, your litigation, implementation, everything within 330 days. I hope this was very clear to all of you. Sure, you can just take a screenshot of this if you require. Okay. Now, once your CIRP ends, okay, once CIRP ends, either you have revived your company or not revived, the liquidation starts. So, if your CIRP is successful, then your company is revived, no need for liquidation. But if you default any implementation of CIRP, or when court did not accept your CIRP, court I mean NCLT, it may order the liquidation. So whenever liquidation is ordered by NCLT, this ends your CIRP. Clear with this? Understood? So I hope you have understood what is a CIRP process. Okay, right from the evaluation till the submission of the CIRP, and after that acceptance approval of NCLT, then implementation of the same. You have to remember what is moratorium, what is a time bound process of CIRP. That's it with the CIRP. Now I hope you have understood what is a CIRP procedure. Now we are going to the liquidation. Okay, if CIRP is successful, there will be no liquidation, but if CIRP fails, there can be a liquidation. So we are going to see liquidation under insolvency and bankruptcy code. Under insolvency and bankruptcy code, the liquidation are of two types. The first one is the compulsory liquidation. Okay, first one is a compulsory liquidation, and the second one we have is a voluntary liquidation. First one is compulsory and second one is voluntary liquidation. Now, who does the liquidation? Who is the authority for the liquidation? It's an NCLT, the same authority. So what is the meaning of compulsory liquidation? Compulsory means it is not intention of company to get liquidated, but because of some reason it has to get compulsorily liquidated. What are the reason? We are going to see. And what is voluntary liquidation? Company suo motu wants to get itself liquidated. So first we will see what are the reasons for the compulsory liquidation. First reason is where NCLT does not receive any CIRP plan. Okay, we have to give CIRP plan with the time limit. If the time limit is not complied of, then NCLT may order for liquidation. So NCLT does not receive resolution plan. Which resolution plan? Corporate insolvency resolution plan. In that case, NCLT may start the liquidation process. Or NCLT has received the plan, but NCLT rejects the plan. We have seen no that NCLT may reject the plan if not found accurate. After that, the third one, we have also seen that before NCLT accepts the plan, if committee of creditors want to withdraw the CIRP, they can do so by doing meeting of COC and passing 90% majority vote. So your committee of creditor itself don't want to continue with the CIRP, but they want to start with the liquidation process. So before NCLT accepts the plan, your committee of creditors, they applies for direct liquidation. What do they apply for? Direct liquidation. Clear with this? Now going to the next fourth one I'm writing over here. We have seen that company has to comply with the order of NCLT in order to implement the CIRP process. But if company contravenes, in that case any of the interested party, they can file a suit with the NCLT and claim that company should go for liquidation and not for revival. Okay, so when company defaults in implementation of order of NCLT. Okay, so plan which is approved by NCLT, company has done default of that. In that case, if company has contravened any condition issued by NCLT, okay, or the interested party means party whose rights are getting affected in the process. So interested party can apply to the NCLT. Interested party can apply to the NCLT, and NCLT in such circumstances order for compulsory liquidation. So if we are not able to implement our CIRP properly without any default, it may lead to compulsory liquidation of our company. I hope this was very clear. Yes. Now, when is your voluntary liquidation possible? When can company start with the voluntary? Means company wants to suo motu start with the voluntary liquidation. Just imagine which company can start with the voluntary liquidation whose assets are sufficient to pay off the liabilities. If assets are not sufficient to pay off the liabilities, first we have to go for CIRP. Over here in the voluntary liquidation, we are not supposed to go for the CIRP first. Why? Because assets are enough to pay. Okay, so what is the first point? Only and only solvent companies can apply for a voluntary application. So voluntary liquidation can be done by whom? Only and only solvent company. Solvent company means whose assets are more than the liabilities. This voluntary liquidation is section number 59 of your IBC. Earlier liquidation were done as per the Companies Act, but when IBC procedure came into effect, now voluntary liquidation is not done under Companies Act, but it is done under IBC. Clear with this? Understood? So who can go for voluntary liquidation? Only solvent companies. So first we are going to see compulsory liquidation procedure, and then we are going to see the voluntary liquidation procedure. Okay, so let's proceed. First of all, we are going to start with the compulsory liquidation. So what will happen when NCLT has ordered liquidation? Compulsory liquidation means NCLT has ordered your liquidation, that this company is going to get liquidated. Start the liquidation procedure. What is the effect of this? What is effect of liquidation? What will happen when liquidation is ordered? First of all, your moratorium ends. When liquidation is ordered, when CIRP gets over, so when CIRP gets over, liquidation is ordered, your moratorium comes to an end. Apart from that, all the pending suits against the corporate debtor have to be only entertained by NCLT. So all the suits have been filed by whom? Your NCLT. Simple. Understood? This is the effect of your liquidation. Please remember. Now, so once your NCLT orders, what will happen? The second thing, NCLT shall appoint a liquidator. Who will appoint a liquidator? NCLT. Who can be the liquidator? Liquidator can be your insolvency professionals. Okay, insolvency professionals can do CIRP also, they can do the liquidation also. So NCLT has ordered for the liquidation and also appointed the liquidator for your company. Now what will your liquidator do? Liquidator shall take charge of the management of the company. What it shall do? Take charge of the management of your company. Okay. Once it takes the charge, it shall publish in the newspaper saying that company is going for liquidation. If anybody has any claims against the company, please come right now, because once liquidation process is over, we won't be able to entertain any claims. Okay. So liquidator shall publish an advertisement. What it shall give in the advertisement? That company is getting liquidated. Okay, and if anybody wants to give the claim, give the claims to the liquidator within 30 days of the advertisement. Simple. So this will be a public advertisement. So what did liquidator do till now? He took charge over the management and then he gave the public notice. After that, he shall prepare a report on corporate data. What it shall do? Prepare a report on the corporate data. What is a report? How many assets are there? How many liabilities are there? So total report will be drafted by your liquidator. Okay. After that, the fourth step. After report is made, whatever assets are there, he shall sell off that assets. Okay. So he shall sell the assets of the company. Okay. Once assets are sold, money will be realized. Okay, with the help of this money, company have to make the payment. Now this payment is done on priority basis. This priority basis we are going to learn in the waterfall arrangement. Okay, yes. So how we are going to pay off that? as per waterfall arrangement. Okay, what are we going to do? Company is going to pay off as per the waterfall arrangement. After that, the fifth one. Once he has sold off the assets, liquidator shall submit the report to the NCLT. Okay, which report? This report is after giving off all the claims. Balance will not be there because company was not a solvent company. Understood? So when company is not a solvent company, balance won't be there. Okay, so it shall make a report after realization, after paying off, and submit the report to the NCLT. Along with the report, it shall also apply for dissolution. Also apply for dissolution. I know many of you think that dissolution winding up is one and the same. No. Liquidation is an initial process where company's assets are realized, liabilities are paid off, balance if any is paid to the creditors. Balance if any is paid to the members of the company. Once your assets are realized, liabilities are paid off, it is called as company is liquidator. So now company does not have anything, no asset, no liability, it is just zero. So when it is zero, then the last stage towards the company is we have to apply for the dissolution. So dissolution starts when liquidation of the company is over. Okay, so till now what we did liquidation of the company. After that we submitted report to NCLT saying that we have liquidated the company, claims are paid off, everything is done. Now please approve our dissolution. Now what will happen next? It's not required that whenever liquidation happens, the last stage is dissolution. No. When company is zero, okay, at that stage also, any promoter of the company, any investor can come and merge the company with their own, or they can purchase that company. So liquidation always does not amount to dissolution. But dissolution always amount to closure of the company. I hope this is very clear to all of you. So liquidation is the initial stage and the dissolution is the last stage. So liquidator shall apply for the dissolution with the NCLT. Okay, and if NCLT is satisfied, I'm writing in the next point over here only, it shall order for dissolution. Okay, NCLT shall grant order for the dissolution. Clear with this? Understood? Okay. Now, is our work over? No. This we need to update with the ROC also, because ROC is maintaining the register of companies. So, file order of NCLT with ROC. Inform INC 28. I hope you remember this form. Okay, and now ROC shall make changes in master data of company, where it will write that now company is no longer in existence, it is liquidated. Clear with this? Understood? This was a procedure of a compulsory liquidation. Now as I told you, what happens after the liquidation? Okay, oh, listen to this very carefully. After liquidation is over, okay, it always does not amount to closure. It always does not amount to dissolution. Okay, any of the promoter, that if not dissolution, then what will happen? Any promoter or any investor may purchase the company. Clear with this? Understood? Any doubts? Okay. Now we are going to start with the next liquidation, that is voluntary one. I have told you there are two requirements of the voluntary. No ma'am, you have told us only one. Okay. The other one I'll be teaching you over here. Okay. So when voluntary liquidation company wants to do, what is a voluntary application? Company suo motu wants to do liquidation. So when company suo motu wants to go for the liquidation, there are certain criteria. First criteria, I have told you that company has to be a solvent company. What is a solvent company? The assets are enough to pay off all its liabilities. Okay, so such company need not go to CIRP process, but directly it can go for voluntary liquidation. Earlier, voluntary liquidation used to happen as per Companies Act 2013, but now voluntary liquidation happens as per the IBC. Please remember section 59 of IBC. Okay, so what is the first condition? Company has to be a solvent company. And second condition, that company is not getting liquidated just to defraud the creditors or defraud anybody. Not getting liquidated for defrauding anyone. Okay, if these two conditions company is fulfilling, it can go for a voluntary liquidation. Now why any company will want to go for voluntary liquidation? Why specific voluntary? Because in this voluntary liquidation there is least NCLT interference. Okay, we have seen the compulsory liquidation. In that, NCLT appointed the liquidator. It ordered how meetings of the creditors and everything shall happen, right? But over here, all the things, right, from appointment of liquidator to meetings, everything will be decided by the company only. So voluntary liquidation means it's a least NCLT or any of the official regulator. Very clear with this? Understood? So let's quickly start with the procedure. Procedure is very interesting. Procedure for voluntary winding up or liquidation. Okay, with section 59 of IBC, please remember. First of all, company has to give declaration to the ROC that it is a perfectly solvent company and it is not closing down the company for defrauding anybody. And we are starting with the liquidation, which is a voluntary liquidation. So first of all, declaration to be filed by company with whom? With ROC. Okay, what declaration they are going to file? They are going to file two declaration that company is a solvent company and it is not going to defraud anyone. Okay, and company is starting with the voluntary liquidation. I hope this is very clear. Okay, so company is starting off with the voluntary liquidation. It is perfectly solvent company. It is not defrauding anybody by doing the liquidation. So this was a first step. Now the second step, after the declaration is filed, this point we will mark it as A. Okay, there is some reason, I'll tell you. Second, company has to hold a general meeting and it has to pass a special resolution. So members have to give approval for this voluntary winding up. If company has a debt, see, company can have debt, but asset should be enough to pay off that debt. Okay, so in case company has debt, in that case company has to call meeting of all the creditors of the company. In that meeting they have to take consent of creditors by passing resolution of two-third majority. Two-third majority means what? Suppose 100 creditors are there. Okay, so out of 100, those 100 creditors are holding 10% each in the company. So at least 75% of creditors should give consent. So it is not like your general meeting, whoever members are present, out of that 75%. No. This two-third means creditors who are holding at least two-third debt in the company. Okay, their consent is required. So company shall hold the meeting of creditors and take the consent in case there is a debt. Now this point we will mark as B point. Okay, what is the A point? Filing of declaration with the ROC. What is the B point? Calling of the meeting of members and the creditors. Now going to the third point. Third point talks about company shall appoint a liquidator. Okay, liquidator will be compulsory. In case of compulsory liquidation, who appointed the liquidator? NCLT. But for voluntary, company is appointing. But this liquidator has to be a person who is not related to company. If he is related to company, he cannot hold that position. Okay, so company has to appoint a liquidator within 4 weeks of filing declaration. When they have to appoint the liquidator within 4 weeks of filing declaration with the ROC. So I can also say within 4 weeks of A. Okay, so company will be appointing the liquidator. After that, the fourth point, company shall publish a notice in the newspaper. Company shall publish a advertisement or notice in the newspaper, in two newspaper, one in English, another one in the vernacular. Okay, what it shall write? That we are going for liquidation. If anybody wants to present their claims, please present to the company within 30 days. Okay, so what is the time limit? Within 30 days. This advertisement in the newspaper has to be given within 5 days of meeting. So I can say within 5 days of point B, they have to give the advertisement. Clear with this? Understood? So company appointed the liquidator, also gave the advertisement in the newspaper. After that, we will write the fifth point over here. So now your liquidator is appointed. So what will liquidator do? Take up the management, and liquidator shall intimate ROC and IBBI, that is Insolvency Bankruptcy Board of India, that we are in process of voluntary winding up. So liquidator shall appoint ROC and IBBI. Both of these authorities have to be appointed, that we are going for the voluntary liquidation. Okay, so when this has to be given, this intimation has to be given within 7 days of the meeting. So within 5 days we give advertisement, within 7 days of B, what we are doing, we are giving intimation to the notice. To whom? ROC and IBBI. Okay. After that, sixth point, next one. Liquidator now shall start the evaluating. Liquidator shall evaluate the assets and the liabilities of the company. As per that, it shall make a report of the same. What it shall do? It shall make the report of the same and submit the report with the corporate data within 45 days of the meeting. What it has to do? Liquidator has to submit the report to the company. When? Within 45 days of the meeting. I hope you're getting the sequence. Okay, we gave intimation, then commenced the meeting. After that, appointed liquidator, published advertisement, intimation to ROC IBBI, and now evaluating the assets and liabilities. Okay, after that, the next step, seventh step. I hope you remember we had given a notice. So in that notice, claims may have received from outside as well. So liquidator shall start doing evaluation of the claims. Okay. Whatever claims we have received, that evaluation liquidator shall do. When it shall start doing that, it has to start doing it within 45 days of last received claim. So on the 30th day we may have received the last claim, so within 45 days it has to start doing the evaluation and also complete the evaluation. After evaluation is done, it has to open a bank account, and bank account will be opened in the name of voluntary liquidation. Okay, what is the name of the bank account? Voluntary liquidation. This has to be opened in the scheduled bank only. Okay, then ninth point, liquidator now shall sell off the assets. Okay, and out of this assets, whatever money is realized, okay, out of the asset, whatever money is realized, it will be deposited in this scheduled bank account called as voluntary liquidation account. Why? Because from this account only company will be paying off its all creditors, claims and outstanding debts. Okay, so it shall sell the assets and it will receive money in which account? Voluntary liquidation account. Okay, so this was your ninth point. Now 10th one, it will be responsibility of liquidator to pay off all the creditors from 6 months from realization of the assets. So all creditors to be paid within 6 months of realization of money. So within 6 months of realization of money, what will happen? It shall pay all of its creditor. Once all creditor is paid off, then it will be duty of liquidator to make a final report. Okay, liquidator shall draft a final report. This final report will be sent to 3 authorities: ROC, your own company called as corporate data, and Insolvency Bankruptcy Board of India. So liquidator shall be sending this final report to ROC, your company, and the IBPI. After that, once report is sent to all the authorities, now liquidator shall apply for the dissolution of the company, because last stage is a dissolution. So application for dissolution to be made to whom? Now NCLT comes into picture. Okay, so in voluntary, did we see any time going for NCLT? No. Once everything is done, once company is liquidated, then only we go to NCLT that our company is duly liquidated. Please grant us dissolution order so that our company will not be in existence. Okay. Yeah. So once application goes to NCLT, it may accept our application or it may reject our application. So if it is accepting our application, it shall give us order for dissolution. Okay. If it is rejecting, we cannot dissolve our company. We have done something wrong in the liquidation. Okay. Now case will be going on in the NCLT. Clear with this? So Once order of dissolution is issued, this we have to file with the ROC. This we have already seen in which form? INC 28. And then ROC shall make the changes as company is dissolved. Clear with this? This INC 28 we have to file with the ROC within 14 days of receipt. 14 days of NCLT order. Clear with this? Understood? So this was a process of voluntary liquidation. Now let's revise it one more time. You can take the screenshots as well, no problem at all. Yes. So this is your voluntary liquidation, section number 59. You can apply solvent company and any company which is not defrauding anyone by the liquidation. So there is least NCLT interference. We already saw that. So first of all, company shall file application with the ROC that we are going for voluntary liquidation, but we are solvent and not defrauding anybody. Then company is going to convene a general meeting and pass a special resolution. If company has creditors, then convene the creditors meeting and pass a resolution of 2/3 majority consent. After that, company shall appoint a liquidator within 4 weeks of filing of declaration with ROC. Then publish advertisement in newspaper, in 2 newspaper, that we are going for voluntary liquidation. If anybody has claims, do give us claims within 30 days. This publication company has to make within 5 days of the meeting of the shareholders. Also, liquidator shall appoint ROC and IBBI about the voluntary liquidation within 7 days of the meeting. Then liquidator shall take over and evaluate the assets liabilities, make a report, submit the report to the company within 45 days of the meeting. So once report is sent, it shall start with the evaluation of the claims and it has to finish the evaluation within 45 days of last received claim. It has to open a bank account called as a voluntary liquidation account. So whenever assets are realized, all money will go in this scheduled bank account only. Once assets are realized, creditors shall be paid off within 6 months of realization. After company is totally liquidated, balance will be there in this case, and if any, it will be given to the equity shareholder. So final draft report will be sent to ROC, the corporate debtor and IBBI. Then liquidator shall make application to NCLT for the dissolution. If NCLT accepts, it shall give order for liquidation, that is dissolution, and company has to file the same with the ROC in form INC 28 within 14 days of receipt of order. If it rejects, then again multiple suit shall happen. So I hope you have understood what is voluntary liquidation. Now I hope you have understood what is a liquidation, what is voluntary and compulsory liquidation. Now in this video we are going to learn about the waterfall arrangement. Now what is this waterfall arrangement? When any company is an insolvent company. Okay, so when liabilities are more, assets are less, they have to go by the CIRP process or the mandatory liquidation process. So whenever liquidator realizes the assets and it starts paying off the liabilities, as the assets are not enough, it has to prepare a priority list. So can liquidator prepare that list as per his own consensus? The answer is no. The priority list has to be prepared as per waterfall arrangement. How it has to prepare? As per the waterfall arrangement. So waterfall arrangement has been defined under section 53 of the IBC. It provides that the manner of distribution of assets in case of liquidation and order of priority of distribution. Okay, so what is a waterfall arrangement? It's a category of person which will come priority over the another. Okay, yes. So what is a waterfall? It becomes very important to remember. They may ask you a straightforward question. If it comes, it's a jackpot question for us. So first of all, whatever money is realized out of the asset, it will be used to pay off the insolvency resolution process cost. This definition we have learned in the video of a definition. Also, the liquidation cost in full. So both costs will be covered in full. After that, B. Workmen div and debts of secured creditors, they have a equal standing. Okay. So following debt shall rank equally between these two. Any workman due which is pending 24 months prior to liquidation. So any laborer or workman due is pending at only 24 months, not more than that, for liquidation. Or dues of your secured creditor. So workman and secured creditor comes on the same line. Now C category, third priority is wages or any unpaid dues of employees other than workmen. So for employees, their dues not exceeding 12 preceding months of the liquidation. After that, the next priority is unsecured creditors. The next priority comes is again the tie two people. First, any amount due to the central government, to the consolidated fund of India. That means as an income tax or any other taxes, we have to pay something to the government of India in respect of whole or any part for 2 preceding years. For 2 preceding years, whatever are dues for the government, we have to pay them. Then debts of your secured creditors under your SURFACE Act. Okay, so when company is going for liquidation, even they have to follow the SURFACE Act, and any enforcement of interest, the secured creditors. After that, the remaining dues or the debts, if anything is left, okay, it shall be paid to the preference shareholders. After preference shareholders, if anything is left, it will go to the equity shareholders or the partners. If company is insolvent, equity shareholders will get nothing because there is no balance. But yes, if company is solvent company, equity shareholders may get it. Now this is the basic priority under waterfall arrangement. Anytime your court or central government, state government may change this order for special circumstances. Okay, so contractual arrangement between the parties about equal ranking, if disrupting order of priority shall be regarded by liquidator. Okay, so if there is any dispute between any two parties, that dispute will be disregarded by whom? Liquidator. Fees of the liquidator will be proportionally deducted at every stage. Okay, so first he has paid for the insolvency cost, so were there some part of liquidator fees. When he is paying B some part of liquidator fees, so this is how he will proportionately deduct his fees from class of recipients. I hope you have understood what is a waterfall arrangement. It becomes very much compulsory to by heart this. Now we are going to start with the next concept over here called as a winding up. I hope you have understood what is a CIRP, how does it operate, and what is a liquidation. Now we are into winding up. Also in winding up, like a liquidation, we have two kinds. Okay, the first one is a voluntary winding up. So voluntary winding up again is governed by your section 59 of IBC, which we have learnt in the previous video, right? And another one, we have a mandatory winding up, or you call it as a compulsory winding up, where your tribunal shall be giving an order that company needs to be wound up because of so and so reason. That comes under section 271 of your Companies Act 2013. Okay, so I hope this is very clear that there are two kinds of winding up under this. One is your voluntary. Voluntary is done under section 59 of the code. and another one is a mandatory one, which is a compulsory winding up by the NCLT, which is governed under section 271 of Companies Act 2013. So before going to the procedural part, let's understand what is a winding up. Winding up is nothing but closing down your company. You're winding up, your liquidation is a one and the same. You're closing down the company, you're liquidating the company, you're winding up the affairs of the company. When I say what's the difference between winding up and a liquidation, order of winding up will set a step towards liquidation. Okay, so once NCLT orders winding up, then we need to liquidate our company. I hope you are understanding it. So what is a winding up? It's one of the reliable economy which is time taken by a company to wind up. Many of the investors don't want to invest in India because the time taken to wind up a company is huge in India, because lot of procedural aspects are there, and earlier the cases were handled by the high courts, and also there was a lot of pressure on our court system. So it took years and years to wind up a company. So this was the reason they did not like to invest in India. Incorporation of companies easy, but winding up was difficult. So this had to be treated, hence we have a easy winding up procedure under IBC, that is voluntary one, section 59. So now winding up and liquidation, both the process are time bound. They have to be done within a period of time. If you don't do it, then you will be penalized for that. This has paved investors to come in and invest in India. Okay, so the major sore point of foreign investor were way closed down to operations. So this is a reason insolvency bankruptcy code came into picture. So what is the winding up? It's a process of closing down the legal existence of company or an LLP. So in this process, what happens normally? Assets are sold. So assets are realized, we call it. What do we call it? Assets are realized. Now when assets are realized, company receives the money. With that money, the liabilities are paid off. And when you are a solvent company, the balance would be there. The balance are given to the contributories. Contributories are your equity shareholders. Okay. So assets are realized, liabilities are paid off, and the balance, if any, is given to the contributories. If there is no balance, then we go through a CIRP procedure, and that they try to revive the company. And if you don't want to go CIRP, directly liquidation is also okay. Then we have to follow waterfall arrangement. There is no balance because the assets are not enough to pay off the liability. So some of them has to be booked as bad debts, right? So once adjudicating authority is convinced that all your assets are realized, liabilities are paid off, surplus is paid off, so company does not have anything, it's a zero, so then your company can go for dissolution. As I told you earlier, dissolution is the last stage. Okay, so winding up and dissolution are very, very different. Winding up is a process to close down the company, and once the process is over, then again we have to apply to the NCLT that please dissolve our company. Understood? So what is a winding up? Winding up means winding up under Companies Act 2013, or it is liquidation under Insolvency Bankruptcy Code 2016. I told you we can interchange this words, no problem. As I told you earlier, we have two kinds of winding up. One is voluntary, another one is mandatory. So voluntary winding up is now dealt under section 59 of your IBC. We don't look into the Companies Act for the voluntary winding up. I hope this is very, very clear. Now, what is a winding up? Whenever there is an inability to pay off the debts, whenever we don't have available assets. So can we go for the voluntary winding up? The answer is no. So we have to go for mandatory winding up, and that mandatory winding up is governed under section 271. So for voluntary winding up, we need to satisfy the condition that we are a solvent company. But when we are not a solvent company, then we can wind up the company as per section 271 of Companies Act 2013. So now let's see what is the difference between the winding up and the dissolution. As I told you, winding up is a first stage. Okay, it's a first stage of ending the legal existence of the company. So at this stage, what happens? Assets are realized, liabilities are paid off, balance if any given to the contributors. But once all those things are over, then we can go ahead for the dissolution. So NCLT shall not give us order of dissolution till the time we have done winding up. Hence I say winding up is first and dissolution is second. So dissolution, I can say it's a final stage for completion of your closing down of entity. So once we complete our winding up, then comes a dissolution. Winding up is handled by liquidator or insolvency professional. Your dissolution is done only by the order of your adjudicating authority. So for your company or LLP, we have NCLT. Okay. Then creditors can prove their claim and winding up, but in dissolution, creditors cannot prove their claim because already everything is realized now, nothing is there. After that, this point we have discussed in previous video also, that always when companies are wound up, it's not required that they are dissolved. So every time winding up may or may not be a dissolution. Some of the promoters may merge that company into their group companies, or some of the investor can take up their company. So winding up does not always result in dissolution, but dissolution is always a dissolution. There is no hopes of a company once we have applied for the dissolution. I hope you have understood what is the difference between the winding up and the dissolution. Okay. Now we are going to see procedure for the mandatory winding up. Which procedure are we going to see? This is a mandatory winding up. When are we going to take up this mandatory winding up procedure? When we have insufficient assets to pay off the liabilities or any of this. What about your voluntary winding up? It is same like we have learned in the previous video. Okay, so voluntary winding up is as per section 59 we have already done. So now we are going to see what does your section 271 of Companies Act 2013 say. So it says that company can be wound up by your NCLT. So over here NCLT interference shall be there. So company can be wound up by the NCLT in this following cases. Now it becomes very important to remember all of these cases. So when company wants to wind up but it don't have sufficient assets, they can apply under section 271 by passing special resolution in the general meeting. Okay, and the matter will be taken over by the NCLT. Again, if company has acted against interest of sovereignty or integrity of India, or it has done something against the security of the state, or it has done something which is hampering the friendly relations with the foreign state, or company has done anything which is against the public order, morality, decency. In that case, compulsory winding up may be applicable. Okay, or application is made by your ROC. Now even ROC can apply to the NCLT that please wind up this company. It can be any reason. Now what are the reasons and why ROC shall apply? ROC shall apply for winding up of the company in case of affairs of the companies are conducted in the fraudulent manner, or they are carrying on activities in fraudulent manner, or it was formed for the fraudulent purpose or the unlawful purpose, or the management of the affairs of the company is guilty of some fraud. The directors are guilty of some fraud or misfeasance or misconduct. So in that case, ROC may apply for the winding up of company under section 271. But remember one thing, whenever ROC wants to apply, it will be compulsory to take CG approval. So ROC shall have to take CG approval before applying for this winding up application. Without CG approval, it cannot apply to the NCLT. Then, if company has done default in filing your financial statements and annual return for continuous 5 years immediately preceding financial year, then also in that case NCLT application can be given. If your NCLT is of opinion that for some reason which is just unequitable, it is very much correct to wind up the company, so NCLT may wind up. So how many steps did we see? Please mark it. 5 points. First, by special resolution when company is not having sufficient assets. Second, integrity, sovereignty of India, friendly relationship, security of state, public order, morality, decency. Third one, ROC is applying because of fraudulent formation, unlawful purpose or fraudulent affairs of company, management guilty of any of the fraud, misfeasance, etc. And the last one, if company has not filed its financial statement annual return for consecutive 5 years immediately preceding financial year, in that case also this application can be given. And the last one, just and equitable. So when this application is given, okay, first of all let's understand who can give the application. Okay, who can give the application? The application can be given by all or any of this. Company itself, yes. Its contributors, the equity shareholders can give. Okay, both of them combined can give, that is company and equity shareholder, that is contributories. ROC may also give, but ROC will require a central government approval. Any person authorized by central government can give. In case of contributory, when your central government or state government, they have invested or they are the investors, even they can apply in point number B. Okay, so if state government or central government are investors in that company, even they can apply as a contributor. Understood? Now, once application is given, once petition is given, something which is filed with the NCLT is called as a petition for winding up under section 271. Okay, except of this point, except of ROC application, all of this shall require to give application to ROC. Okay, so once NCLT receives the petition, it will be duty of NCLT to send notice to the ROC. Okay, yes, it will send notice to the ROC saying that your company is getting wound up. So if you have any problem, please write to us within 60 days from receipt of such petition. Okay, so ROC confirmation is required, but is confirmation required when ROC himself has filed the application? The answer is no. Then in that case it won't be necessary. Then section 272 says that whenever petition is filed, okay, and ROC gives their views, taking into consideration everything, tribunal may pass any of this order. Don't get confused over here. We have not finished the case till now. Okay, NCLT has went through the petition and now it is giving the order. Now which order is this? Dismiss it because it does not find anything relevant, that company should not be wound up. Dismiss it. Second, it may give interim orders. Interim orders means before giving final judgment, in between whatever things are required for a status quo, then NCLT may give the interim orders. If it is satisfied that company needs to be wound up, okay, then it will appoint a provisional liquidator for that. Provisional liquidator can be your insolvency professional. It may make order of winding up of the company or any other order. Now, whenever it appoints this provisional liquidator, it will be duty of NCLT to give opportunity of being heard. Okay, opportunity of being heard is to be given to whom? To the company. So before appointing the liquidator, opportunity of being heard is to be given, because this is a principle of natural justice, and NCLT being a quasi-judicial body, it will be its duty to follow the principles of natural justice. I hope you have read this in your JIGL, right? Okay, so now it has made the order. Considering that it has appointed the liquidator, so as I told you, opportunity of being heard shall be given before appointment of provisional liquidator. Okay, then the winding up order is given. So in that case, what will happen? It will be in favor of creditors, contributories, it will be in everybody's favor. Okay, so once your provisional liquidator is appointed, it has to submit a report. Which report? A report of what is status of company today, how many things company has, what are the assets, liabilities, trademarks, copyrights, what all things company has. Okay, so that report has to be submitted to the NCLT by a provisional liquidator within 60 days from the order of winding up. Okay, so what will be the inclusions in the report? This becomes very important, can be asked in exam as a straightforward question. So what all things he will be reporting? Nature and details of assets of the company, where are they located? It has to give details of cash and bank balance separately along with the negotiable instrument. Also, it has to submit a valuation report and what is the today's value, and this is to be taken by the registered valuer. Okay, this you will be learning in your company law. Then what is the amount issued, subscribed and paid up? How much is the existing and the contingent liabilities? And we have to specify name, address, occupation of the creditors of the company. Each person, how much is a secured date, how much is an unsecured date. Okay, in case of secured date, what all securities are given as a charge, okay, on which all securities the charge is created. Then how much is a debt due to the company? Okay, debt due to the company. So how much company has to receive? So name, address, occupation of person from whom they are due, and how much money the company has to take. How much guarantees companies have extended. Then list of contributories and their dues, anything if it is unpaid from contributories and details of that. What are the details of trademarks, intellectual property if company is having? What is the status of contract, joint venture, collaborations, whatever company has entered into? What about holding and the subsidiary companies? The legal cases and the details regarding the legal cases and any other information which your tribunal requires your liquidator to give. So this is the entire report which liquidator shall be giving to the NCLT. Once assets are realized, liabilities are paid off, then liquidator may apply for the dissolution of the company. Okay, so once your company is completely wound up, liquidator may apply for the dissolution or tribunal himself may give the dissolution order. So once application is filed, if tribunal is of opinion that it is just and reasonable to dissolve the company, it shall make the dissolution order and company shall be dissolved from the date which is written in your dissolution order. I hope this is very clear, guys. So this was your voluntary winding up, and the compulsory winding up, very important, was section number 271. Now we are going to study about summary procedure for the liquidation. Now we have seen that winding up, liquidation of your company and LLP, it is done by your NCLT. Who does? It is done by your NCLT. But the summary procedure now will be done by your central government. Who shall do the summary procedure? The central government shall do. Now why this? This is the provision to reduce the burden on the NCLT. So in order to reduce the burden on the NCLT, we have come across a provision where the summary procedure, very fast procedure, will be done for the liquidation of certain kinds of company by the central government. In the civil cases, criminal cases, you might have heard about something called as a summary trials. So summary trials are done very fast. On the same lines, all the orders of the winding up, liquidation will be given by your central government instead of the NCLT. So which all companies can go for this? We are going to see the list. Very important for you to remember that list. So any company whose asset of book value is not exceeding 1 crore. So any company which is not having an assets of more than 1 CR can go for the summary procedure of liquidation. Also, there are other classes of company. So central government may order for winding up under this procedure if the book value of your asset is 1 crore rupees or less than that. Also, any company which is having deposit, taken deposit, including your outstanding deposit, okay, it should not be exceeding 25 lakh rupees, or total outstanding loan of your company, including your secured loan, secured, everything, cannot be exceeding 50 lakh rupees, or company's turnover is only up to 50 crore rupees, not more than that, and company does not have paid up share capital of more than 1 crore rupees. So along with the book value of not exceeding 1 crore, paid up capital cannot be exceeding 1 crore, turnover cannot be exceeding 50 crore, deposits cannot be exceeding 25 lakhs, total outstanding loan cannot be exceeding 50 lakh rupees. Please remember this. Such kind of company can apply for the summary procedure for liquidation with the central government. Okay, so how does it operate? Let's see. Central government shall appoint official liquidator. Okay, OL stands for, it's an official liquidator. So official liquidator, it will be appointed by your central government. All the fees, everything will be given from the central government funds only. So it will be its duty to maintain the register record in the same way which a liquidator of NCLT has to maintain. So it has to maintain proper registers and books of accounts. Also, it will be compulsory to file the official liquidator's account. Okay, and what is the procedure laid down? The detail of procedure is not applicable to you. Only remember, it has to give account to the central government that how much money it was realized, how many liabilities were paid off, and what is the remaining, is it given to the contributories or not. Now, for disposing the assets, they require authority from the central government. So whatever monies are realized, okay, it will be deposited in the public account in India. Okay, so it will be deposited in the public account in India not later than next working days. Please remember this. So for proving the claims, the tribunal, whatever powers are there with the tribunal, same power shall be for the central government. Rest all the procedure like giving public announcement for the claims, giving the report, everything remaining the same, but over here NCLT shall be substituted for the central government. I hope this is very clear to all of you. Okay. Now we are going to learn about PPIRP, that is a pre-packed insolvency resolution process. Now this is very new into your CIRP because this is effective from 4th of April 2021. Basically, this PPIRP has been established or included in your IBC just for helping your MSMEs to come out from the COVID pandemic. We know that a lot of businesses have stopped because of this COVID pandemic. The most affected ones were MSMEs, that is micro, small, medium enterprise. So in order to come out of this COVID pandemic, this PPIRP is there. So this makes very clear that PPIRP is only available to MSMEs and not to anybody else. Okay. So what is the aim of this? The aim of PPIRP is to give an opportunity to your MSMEs so that they can come out of the COVID pandemic. It also acts as a one-time settlement with their creditors, and your MSMEs will be run by the promoters. Now what do we mean? In CIRP we have seen that once the liquidator is appointed, your insolvency professional is appointed, the board of directors shall not be running the affairs of the company. But in the PPIRP, the process of insolvency resolution is going on, and the other side, the company will be run by the promoters only. Okay, so this is like a one-time opportunity given to the micro, small, medium enterprise that your affairs will be handled by your promoters only. But on the same lines, it will help to overcome your COVID pandemic. Okay, this is a peculiarity of this. Now, what is the eligibility of PPIRP? Only micro, small, medium enterprises are allowed for the PPIRP. So no private, public, other companies who are micro, small, medium will be allowed. Now what is MSME? This we have already learned in chapter number 13. The definition of micro, small, medium enterprises, right? Yes. So those fitting into criteria of micro, small, medium shall fit into this PPIRP. Also, their minimum default should be of 10 lakh rupees. If minimum default is 10 lakh rupees, then only they can apply for the PPIRP. Both these conditions are to be satisfied. Now, which MSMEs are not eligible for the PPIRPs? Okay, so even if they are MSMEs, even if they are having default about 10 lakh rupees, still they are not able to file PPIRP. Why? Because of this reasons. Only 4. 1. They have completed their PPIRP or CIRP 3 years preceding the initiation date. So already they have completed before 3 years. So again after 3 years they won't be allowed. Yes, if it is 4 years, 5 years, 6 years, they can do it. Okay, this provision right now would not be efficient enough because PPIRP came just now, but yes, you can say yes to the CIRP. CIRP has come from 2016, right? Or any company which is CIRP process is going on, they cannot apply for the PPIRP. Any company's liquidation process is going on, they cannot apply for the PPIRP. Any company which is not eligible to submit the resolution plan, they cannot apply for the PPIRP. So please remember. After that, once your MSME has decided to go for the PPIRP, they have to form a meeting or call a meeting of their financial creditors. Those financial creditors should not be related to the company. Okay, so they should not have any relationship with the company. So there has to be meeting of such financial creditors. And in the meeting of financial creditors, they shall be proposing one person's name or group of persons' name who can act as a resolution professional or an insolvency professional for carrying out the PPIRP. Okay, so over here the professional is appointed by whom? The financial creditors of MSMEs. So once the proposal is made, it has to be approved by unrelated financial creditors of the company by passing resolution of at least 66% in value. So suppose total debt of the company is 1 crore rupees. The creditors holding, that is the secured creditors or unsecured creditors who are holding at least debt of 66 lakh rupees, they should approve this. I hope this is clear. So financial creditors should be unrelated. They will be proposing and approving your insolvency professional. So once your insolvency professional is fixed, appointed by the company, the corporate data, next, the majority of the director have to give certain declarations. Now, what declarations they have to give? That they are going to file the PPIRP within 90 days. So, they are going to file it as early as possible within 90 days. And they have not initiated this PPIRP in order to defraud any person. It can be creditor, company, shareholder, anybody. They have not initiated to defraud anybody. And the name and approval of your insolvency professional is done by whom? Your unrelated financial creditors. This 3 declaration will be given by a majority of your directors. Okay. After that, company need to convene a general meeting and pass a special resolution. In that, approval of shareholders will be taken to initiate the PPIRP against the company. When you are having a LLP, you have to take consent of at least 3/4 of number of your partners. That is a special resolution also in the LLP in order to initiate your PPIRP. So once financial creditors and companies consent, shareholders consent is taken, so corporate data shall also take the consent of financial creditors to initiate the PPIRP against the company. This all things company is doing itself. But in CIRP we have seen that this all things were done by your liquidator, but over here company is only doing it, right? So corporate data shall take approval of financial creditor to initiate the PPIRP What is a resolution? How much percentage resolution is required? Approval of 66% of voting. Okay. Now the application of PPIRP is to be filed with the NCLT. Now along with the application, company has to submit other documents also. So what all things it needs to submit? A declaration of majority of directors, then a special resolution, and approval of financial creditors to initiate the PPIRP. Along with that, the name of the insolvency professional who is elected for the PPIRP and his written consent that he wants to become the insolvency professional for the company. Then the declaration that there is no fraudulent transaction which is pending against the company and this company is not doing PPIRP for any defrauding of any of the members. Also, they need to give all the information about the books of accounts and the registers of the corporate data. Okay, so this is the application filed with your NCLT. Once NCLT receives the application, it has to either accept it or reject it within 14 days. It will accept it if the application is complete. It may reject it because of some defect. So when it is rejecting because of some defect, it should give one opportunity to company for resubmission of that within 7 days. So company shall resubmit the application by correcting the defect within 7 days. After that, it may accept or reject, but they have to give reply within 14 days. So once your application for PPIRP is accepted, admitted, from that day it will be deemed to be commencement. Okay, so your PPIRP commences on the date when it is admitted by the NCLT. Now, what is the time limit for completion of PPIRP? Very important. For CIRP we have seen that 120 days, extension of further 90 days, not exceeding 330 days in total. PPIRP has to be completed within 120 days. Yeah, for CIRP I told 120, but sorry, it was 180 days, right? Yes. So for PPIRP it is 120 days. They have to complete within 120 days. And they have to submit the resolution plan. Your corporate data or your resolution professional have to submit the plan within 90 days from the commencement. Complete proceedings within 120 days, submit the plan within 90 days. Okay, and if your committee of creditors, COC's committee of creditors, if they are not able to approve plan within 90 days, then what will happen? Insolvency professional may make application to NCLT for termination of PPIRP. Got it? Because COC or the corporate debtor has to file the resolution plan with the NCLT within 90 days of commencement. If they are not able to do so because of the committee of creditors, insolvency professional can apply for termination of PPIRP. I hope this is very clear. Now once your PPIRP commences, NCLT may announce a moratorium, same like the CIRP. Yes. So once PPIRP commences, NCLT shall declare the moratorium. Then the person who is approved by your financial creditors for the insolvency professional, that person shall be appointed as a resolution professional or insolvency professional, you can say, by the NCLT. And your insolvency professional shall make a public announcement that we have started with the PPIRP. If anybody has any claims towards the company, please come forward and submit the claims. Okay. After that, the list of claims and preliminary information memorandum. Now, once your PPIRP is commenced, it will be duty of your corporate data to submit within 2 days the following things to the resolution professional. So what all things corporate data needs to submit? All the list of the claims along with the details of your creditors, how many guarantees are given, etc, etc. Also it needs to give an information memorandum to the resolution professional so that it will help the resolution professional to make a plan, that is a resolution plan for the corporate data. Okay, so these two things corporate data have to give to the resolution professional, or we can say insolvency professional, within 2 days of commencement of PPIRP. Whenever your PPIRP is going on, Okay, whenever PPIRP is going on, as I told you, the affairs of the corporate data will be with whom? Will it be with the insolvency professional? No, it is with the board of director, and it will be duty of board of directors to preserve, protect the property of the company. Okay, once your PPIRP is commenced, insolvency professional has to establish or constitute a committee of creditors within 7 days. Once committee of creditors is constituted, they have to do their first meeting within 7 days of the constitution. After that, as I told you earlier, the wasting of management of corporate data generally lies with whom? Board of director. But if your committee of creditors feels that your management of the company needs to be given to the insolvency professional and not to be kept with the board of directors because of some reason, they can hold a meeting and approve this by 66% of voting. Once it is approved by 66% of voting, they can make application to the NCLT asking for wasting management with the insolvency professional. NCLT may approve the claim of the committee of creditors if it thinks that affairs of the company are conducted in the fraudulent manner or there is some gross mismanagement done by the affairs of the company. Okay, so in this scenario, NCLT may approve the wasting of management with the insolvency professional. So in this case, company has to hand over, board of directors have to hand over the management of corporate data with whom? Now insolvency professional. Now same like CIRP? Yes. So once management goes to the insolvency professional, all other provisions from there of CIRP shall be applicable. So henceforth insolvency professional shall be handling everything about the corporate data. I hope this is very, very clear to you. Okay. Now supposing the wasting of management is done, everything is done. Now there is something called as consideration and approval of resolution plan. Resolution plan is very, very important, be it a CIRP, be it a PPIRP. So resolution plan will be made by your insolvency professional and the CIRP by taking the notes of your committee of creditors. But over here, your corporate data shall be making the base plan. So corporate data shall be submitting the base plan within 2 days of commencement of PPIRP to whom? The insolvency professional. So corporate data will make the plan that we want to do the resolution of a company like this. Okay. So the plan which is submitted by corporate data, resolution professional shall submit same to the committee of creditors. If committee of creditors want to improve on that plan, it may improve by giving opportunity of being heard to the corporate data, or they can approve the plan as it is. So if your COC is satisfied with the plan, they may approve plan. And how they can approve the plan? By 66% of majority. And when COC approves the plan with or without any modification, then the plan is ready to be submitted to the NCLT. But generally it does not happen like that. Resolution professional will always want a competing plan, that something may be better. So it will always invite the resolution applicants that this is the base plan of a corporate data. Do you have any other plan which is more better than that? So resolution applicant shall be submitting their plan which is more better than base plan. So both the plans will be viewed, okay, and the best one will be selected. The selection will be done by committee of creditors. So if your base plan is not so good, but your resolution applicant plan is more good, significantly better, it may be approved by committee of creditors by passing 66% of the majority. So once your plan is ready, we have submitted the plan to NCLT, and NCLT may approve or reject our plan within 30 days. If it is happy with us, happy with the plan, then approve within 30 days. Not happy with the plan, not satisfied, then reject within 30 days. One more scenario is there where NCLT may reject our plan, where NCLT has ordered wasting of management in the insolvency professional. But in the plan, The committee of creditors has not shown any such thing. So still the management is with the board of directors. So this is contravention of order of NCLT. So in that case, NCLT may reject the resolution plan, or it may even terminate the PPIRP, directly order for the liquidation. Also cost which is involved will be included in the liquidation procedure. So this becomes very important to remember. If NCLT has ordered the wasting of management in the insolvency professional and it has not been complied with, then these three things may happen. Now, when does your termination of PPIRP happen? Once plan is submitted to NCLT, everything is done. So NCLT within 30 days may approve or reject. Okay, within 30 days, which is application given by your resolution professional, it may terminate the PPIRP. Now in which cases it may terminate? If your committee of creditor was not able to submit the plan within 90 days, or committee of creditor did not select any of the plan, did not select the base plan also, or did not select any other plan. If committee of creditors instead of going to PPIRP directly want to go for liquidation, so they want to terminate the PPIRP by 66% of voting, this can be done. So in this three scenario, your insolvency professional may apply to the NCLT and NCLT may within 30 days of application order for termination of PPIRP. So I hope you have understood what is PPIRP, the process of PPIRP. This was all. So now we are going to learn about fast track corporate insolvency resolution plan. We have already learned about CIRP. So CIRP is to be completed within 180 days plus extension of 90 days. Okay. But this plan is little more faster. That's why the name is fast track. So this was effective from 14th of June 2017. And which company shall be allowed to apply under this plan? The companies which are allowed are your small companies. Yes, this is a small company as per section 2 clause 85 of your Companies Act 2013. Also, startups are eligible to apply, but except of the partnership firm. So even though partnership firm is also a startup, but still will not be allowed to make application under PPIRP, but company and LLPs are allowed. Okay. Then unlisted companies whose total asset as on immediately preceding financial year does not exceed 1 crore. So these three criteria is very important to remember. Those are the eligibility. Now what is the time period for completion of this fast track? The fast track is to be completed within 90 days from date of the commencement. Okay. If your committee of creditors or your committee wants to extend it because they think that it is not possible to complete the process within 90 days, it may apply to the NCLT, but before that it has to take approval of committee of creditors by 75% of voting. So after this resolution is passed, it may apply to the NCLT for extension. If NCLT is satisfied, it may give extension of further 45 days. But extension will only be given once. You will not get repeated extensions. Okay, so maximum extension 45 days and that too only once. Now how fast track resolution insolvency can be initiated? It can be initiated by filing application by your creditor or a corporate debtor along with the following document. What document? We need to submit a proof of existence of default. This proof is to be given by your information utility. I hope you remember the first session where we learned the different authorities under IBC. The information utility will be giving us a proof of existing default. So now what is the procedure? The procedure will be like this. The application is given by creditor or the corporate debtor. NCLT may accept or reject it. Once it is accepted, it will appoint a resolution professional. Once resolution of professional is appointed, within 3 days of its appointment, it has to make a public announcement that we have started with the fast track resolution procedure. So if anybody has any claims, please give us the claims. So claims are welcome up to 10 days from appointment of insolvency professional. Okay. Once claims are received, from the last claim which it has received, it has to finish the verification of claims within 7 days of that. Within 7 days of last receipt of the claim. Where there are no financial creditors or all the financial creditors are related. So we cannot form committee of creditors. So in that case, the committee shall consist of 18 largest operational creditors by value, one representative from workmen and one representative from the employee. So this is your committee in case your financial creditors are not there or all of them are related. So your insolvency professional shall constitute this committee within 21 days of its appointment and also file a report on the same to the NCLT. It shall also convene a meeting of the creditors committee or the other committee which we have formed within 7 days of its constitution. Okay. Now in all the committee or creditors committee under fast track, the resolution has to be passed by 33% of the majority. Okay, it is not like your CIRP where 66% is required. So over here it is 33%. Also, insolvency professional shall appoint a registered valuer within 7 days of its appointment. Whose appointment? Insolvency professional appointment. So your registered valuer shall be giving the valuation of the assets. Now, insolvency professional now shall submit the information memorandum, a base plan basically how it wants to go for the fast track. It is to be submitted via electronic mode to each and every member of the committee within 2 weeks of its appointment and also to every prospective resolution applicant who will be giving a alternative resolution plan for the company to be insolvency free. Okay, this is to be given within 2 weeks to members and the resolution plan applicants. It will also invite the resolution plans from various resolution applicants. Okay. Once the plans are received, it will be compared. The most favored for the company shall be selected by the committee by passing 33% of majority. Once your plan is approved, it will be submitted to the NCLT. Once it is submitted to the NCLT, now when the submission is to be done, the plan will be submitted to NCLT at least 15 days before your expiry period. So your expiry period is 90 days, right? In case of extension, more 45 days. Before 15 days of completion of that period, we have to apply for the resolution plan. So once we submit the resolution plan, if NCLT feels it is good, satisfied, it will accept it and company has to oblige with that plan as well. If company does any contravention, any default in implementation of the plan, NCLT may on application of any applicant may order liquidation. But if NCLT is not satisfied with your plan, it may reject also. So this is your entire fast track procedure. I hope you have understood this. Okay. So we have completed with your chapter number 21. I hope you understood all the aspects: CIRP, fast track, PPIRP, liquidation, winding up. So I hope you understood the entire chapter. Yes. So now let's see what questions are asked. Okay. So first one, the term winding up and dissolution can be used interchangeably to denote the cessation of existing of legal entity. This sentence is not correct. Why? Because winding up is the initial stage and dissolution is a last stage, right? So dissolution begins once winding up is completed. So how can we use interchangeably? This we have learned in the distinguish between the winding up and the dissolution. That is your answer. You have to write the distinction between the winding up and the dissolution. After that, elaborate on the waterfall arrangement under insolvency and bankruptcy code. Straightforward question it is. You have to write the entire waterfall. Okay. Now, explain the term insolvency resolution process cost as defined under Insolvency and Bankruptcy Code 2016. This is also straightforward. We have done this in the definitions. Okay, so what all cost will be included, we have to write. Now, what are the duties of insolvency resolution professional? First of all, it will be taking care of the management in case of CIRP, in case of fast track. It will also be taking powers of board of directors. It may appoint other professionals like registered valuer. Their primary duty is to make public announcement, claims from creditors, get valuation of corporate done correctly, right? So it also needs to constitute a committee of creditors, right? And also there will be duty of insolvency professional to protect and preserve value of the property of corporate debtor. So these all things we need to write. Now, ABC Limited has initiated an insolvency proceedings against RS Limited for recovery of debt of 2.86 crores. Of ABC Limited intends to appoint Rahul, one of the employee of its statutory auditors, Messrs. ASA and Associates, Chartered Accountant, as its resolution professional. In light of statutory provisions, examine whether Rahul can be appointed as resolution professional. The answer is no, because we have learned that our resolution professional has to be independent. It cannot be related. If he is related, he won't be able to give justice to the resolution process. Hence, it will be compulsory that he has to be independent. Okay. So, as per IBBI, an insolvency professional shall be eligible to be appointed as a resolution professional if he and all partners, directors of insolvency resolution professional, which is entity or partner, are independent of corporate debtor. So, if he is not independent, he cannot be appointed. Then, describe procedure mentioned under section 53 of Insolvency Bankruptcy Code for distribution of asset. Please remember, section 53 is your waterfall arrangement. Don't get confused. 59 is voluntary winding up and liquidation. 53 is waterfall arrangement, and this you have to write straightforward answer. Okay. Now, NCLT has passed order of commencement of CIRP of Dora Travels. One of its director has approached you to know effects of moratorium. Simple. You have to write about the moratorium, which we have already seen. Then, Yogendra is allottee of flat in a real estate project promoted by company, but he has not been delivered flat as per the agreement. He has approached you to know whether he can make application under Insolvency Bankruptcy Code and in what status he can make. Also, brief timelines for CIRP process. So easy it is. I have taught you the definition of financial debt. In that, I had told you that whenever any purchaser has purchased a flat by paying the entire consideration and he has not got the allotment of flat on the described date, he will be deemed to be the financial creditor. I hope you remember. So, Yogendra can be treated as a financial creditor, right? Next, Yuan Infra is continuously making losses and directors of company are planning to voluntarily wind up the company. As a company secretary, advise on condition, also advise them briefly on procedure for the voluntary liquidation. Over here, section 59 will be there. As per section 59, under voluntary liquidation, can a company be a loss making? If company is making losses, then also their assets should be more than liabilities, then only it can apply under that, right? So it should be a solvent company and it should not be defrauding any of the persons. Okay. Yeah. So that's it with this chapter. With this chapter, we have completed the entire syllabus of your SBEC. Okay.